Note kar do weekly.
Like how much after that?
I'll just see till 2 o'clock how much I can reach. Okay. Yes.
Much obliged.
You give the memos, we will see. Review petition, no urgency. Yes. It's all right, but what to do? Review.
See, in this case, where lordship on 23rd October, lordship used to extend the entry order till 30th October. On 30th October, one senior counsel, Mr. S.K. Mishra, appear on behalf of opposite part number 2 and matter was adjourned to 26 November. But the interim, though your lordship extended interim order, that has not been reflected in order.
When the matter is
30th October. 30th October.
Let it come on that day.
But only trial court matter.
So nothing will happen one day. What you are not going to be convicted on the same day. Wait, nothing will happen. 30th is the day.
This is the order. This is the order.
We'll see. Let it come on 30th. We'll see.
That
when any adverse order is passed, I'll take care of that. Yes.
My lord,
yes, sir.
My lord, one compromise. But
1 minute. Senior is standing, but give respect to seniors.
My lord.
Now, the income tax department has some problems today.
Which one, sir?
Because my
11. Okay.
on the prosecution.
I'll put it after a week or so.
I'm going for Monday. At least let me be protected. You want me to protect me, and then you'll also make.
I don't know what is this matter. Who is appealing?
This is a matter law where the cognizance has been taken under 276B and 230.
Nothing is going to happen. You don't appear on that day. What will happen? Nothing will happen. Oh, Monday, it's all right. Monday. Keep it on Monday. Okay.
My lord, one bail application that was adjourned for city my case diary long back, my lord. Therefore, bail application that was adjourned for case diary, my lord. Long back.
Case diary, all dates are given.
Said order is not uploaded, therefore I am unable to.
It will be uploaded. Yes. Yes.
My lord, one transfer matter I have time. Yes, I am saying what is the urgency, my lord? I am for the information.
Transfer matters are not here. Assignment. Somewhere else. Not here. Yes.
My lord, the matter amicable settled in between husband and wife.
Offense.
My lord, offense 498 506. And another matter is only 363.
One day, one matter. Whether you want to finish all the matters.
My lord, complaint matter 363 only offense.
Okay, one matter, let us see. You put it that after 2 weeks. Okay.
My lord.
But on that day, you bring the wife and husband and all. Yes. Yes, Mr. Tripathi.
One item, the Supreme Court has granted stay for 4 weeks.
So I pray, my lord, your lordship fix to
Next week.
My lord, next week, 22.
Settle, dispute. Okay.
I already married.
Married. Put it.
20.
Item 77 papers not adjourned, your lordship.
77. Entry what is there?
No,
My lord, entry model adjourned. Okay.
My lord, the modification of order and time for surrender in NBW case. 14.
Yes, take it. Modification.
My lord, the petitioner is filing a case before family court. But after that, the wife has again done 498 case.
It will come in its usual course. What is the great urgency about? Yes.
My lord, serial number 63 complete.
Yes.
my lord, this is a trace Belgium matter, my lord. My lord, another one is a CLMC for quashing of the vigilance case is pending since more than 3 decades.
3 decades.
Yes. 92.
92. Including the wiki. Including that 92 matter including. And give it preference. But yes.
Not item 92, one
Entry model is there? Huh? Why adjournment? I'll see. If there is entry model, I'll see and do adjournment.
Item 90 not pressed.
And 19.
Yes.
And 19 not pressed. 90 not pressed.
Item number 57. I permitted to withdraw.
The 57 would withdraw.
Item
Belgium clear.
Item 5 paper 1 and 10.
5. Yes. Why? 1 week. We go to February. No, February, it will go to February. I'll tell you, once we are adjusting the list in such a manner that we want to take it up. Fresh matter, you want adjournment. It will go to February. Be ready. Either you argue or February. Any fresh matter which is listed, if anyone is asking for time, put it in February. February. Yes.
Item number 14 minutes. I put it for an adjournment.
Which one?
Item number 14.
14. Wait, is there is a position? Okay, there is a position. 1 minute.
Well, item number 65, my lord, in weekly list, my lord.
Yes.
Yesterday I was mentioning my illness, my lord. Ajin working कहला, किंतु 17 बार को आजन है.
So we'll see. Maybe pardon me.
Monday, my lord.
Monday not possible, sir. I can't sit matter. Just see the how many matters it is. Maybe pardon me.
Urgent, my lord. Item number 10 minutes, maybe adjourned to 2.
Why?
Yes, my senior is in this pool. Submitting this.
Then you entry mark. But we'll go to February.
That's why.
No. It will go to February.
Any date in January?
February. If you want adjournment, February. Otherwise, argue.
My
No question. No, whatever.
any date in January last after.
January last day. January last day. It's so difficult to get the matter adjusted in the votes. And once I adjust you ask for adjournment.
Asking for adjournment in some.
If you don't please, then give most. You have to be reasonable to the court also. Yes.
My lord,
Any mention? Yes.
my lord,
Yes,
item number 61, my lordship had passed an order on 12th September 24, and they concealed this order and obtained a stay. I only pray that it was passed by my lordship's order. 10 witnesses have been examined. They concealed my lordship's order.
What you want? I'll take it up. Yes, I'll take it up. Yes. Any mentioning?
My lord,
Yes.
my lord, item 60. My lord, my audible, my lord.
Yes,
My
yes.
lord, item 60, my lord. What happened? My lord and senior lost his brother, my lord, today is 7th. Lordship is.
Okay. There is,
So that's why-
there is, yes, there is 60. Please,
My lord, my lord.
the document is finally approved the counsel for the petitioner and then adjournment is sought. Please do matter after 2 weeks. Notice is also sufficient. You have to take steps, huh? Yes.
Yes, notice is received. It is received. Instead, only his brother expired.
Yes. It's all right.
Can I mention, my lord, one item? My lord, in this case, the Supreme Court has granted stay of
Who is
4
mentioning?
weeks.
Okay. Yes, Mr. Tripathi.
My lord, the Supreme Court in this matter has granted stay for 4 weeks with a liberty to the High Court to consider. I moved an application, my lord, for mentioning, but somehow, my lord, I am requesting, can we have it on 21st of November?
I'm not able to hear you properly. Please be louder.
My lord, this is a matter in which the Supreme Court directed the High Court to consider with regard to the continuance of the stay, because the stay by the Supreme Court continued for 4 weeks. So the
Okay.
application has been filed. I am requesting for 21st of November.
Don't fix the board yourself. Please allow me to adjust my board. I'll accommodate you. Yes.
There is a mentioning memo.
Do you have any junior here?
Yes, he's there.
Please give me. Okay, I'll make it this. 21st, please.
Item 9.
21st of November.
Yes.
Item 9 will be taken up next week.
9.
Pardon to mention that.
What is the any problem with you?
I am very badly placed today. Part of that.
Then you go to January only.
Only let
January. Okay, January last.
Pardon to mention my lord, item 18 and 18 kindly taken up next 2 months.
81. Who is there?
With the lordship's kind permission, with the lordship's kind permission, may I mention item number? Item 133 was there in a weekly list. Your lordship directed
He
them
will
for
be
yesterday.
there. He will
It was
be
supposed,
today.
it was supposed to be listed today, but your lordship,
Is there? Is there? Let me
so
find, allow me to proceed so that I can finish it up and hear you.
we cancelled our ticket today morning. Actually, we were supposed to go, but we saw that there is no noting, nothing in their list. Uh,
It will be scheduled. I told you there is a mentioned. He asked me to hear the matter today, then I said that get ready for the after.
So
What?
if it is there, then we'll do it online, my lord. If it is comes, then
If it reaches, then you definitely argue. Yes.
yes.
Can I make a mention?
Yes.
My lord, item 95.
95, huh?
To compromise, 95, my lord.
Yes.
Parties are present on virtual court, Bhawanipatna, Kalahandi. Can it be taken up at 12, my lord?
12 o'clock.
Oblige.
Correct. Yes.
Pardon me, item 80 and 81 can you take on next to that?
80 and 81, there is stay order is there, so the wait. I'll adjourn it to February and vacate it.
Also, the personal difficulty.
What the personal difficulty? Every time you prepare and come. You prepare and come, we'll see. The other side has to be there. Huh?
Pardon the mention, my lord, this is an evidence issued against the petitioner and the is in custody. In other case, wherein the petitioner will be acquitted. So this is for admission.
Any cancellation of NGO. Yes. Any mentioning? We'll proceed. Yes. Item 1. Yes.
In this item one, my lord, last time I was on my legs in school, so I couldn't come. My friend was doing.
Yes.
I was given to understand, but he couldn't explain properly what document your accession really required. First says, I was the ADM of the Kingdom, that is district headquarters. The person whose bill has addressed to be drawn and dispersed was supposed to work in another station.
Yes.
But I was drawing and dispersing authority has to pass it. According to that procedure, rule is that a working certificate will be given by the person that I worked from such and such period.
Yes.
And on the basis of the working certificate, the salary will be given. The allegation is that he has given those certificates, even though those certificates has been received in the office of the ADM of Kenya. That means in my office it has been received, but it has not been entered in the issue register of that branch. So I was told that last time your mercy wanted the rules for that.
What you should know.
The rules, the financial rules to the financial rule will be prescribing financial.
By the impugn order, what happened?
I have in charge 120 weeks that I connived with him to disperse his salary.
And
I got the
cognizance has been taken.
cognizance has been taken. So actually, the financial rules, there would be a delegation of power of drawing and dispersing authority. So far as the financial bit is for the entire state.
But see, if the cognizance is taken, all these things you can argue at this stage of framing of charge. I give that liberty.
Why, sir? I have discharged my, supposing there is the allegation that I have gone beyond my power and given it, then it is all right. But his allegation is that he has not worked, but issued a foreign certificate which has been received by me and I have dispersed.
What is the allegation? Is that the only allegation? 120?
No.
Yes.
Last occasion, your lordship has extensively harried when your lordship was not inclined to urgent.
Yes.
And your lordship kindly see, in this case, the petitioner along with other ADMOs, the disbursing officers, have granted the salary in respect of a particular person who has never worked, and the salary certificate given by not come from that the CSC of the concerned officer, the delegating officer, Setu Asinahi, and they have all the doctors, the DDOs, have granted the salaries on the basis of false certificate, and this petitioner has granted salary in respect to a year also. He could have verified the same.
He cannot throw away his responsibility saying that
He is not dispersing officer.
he is the dispersing officer, petitioner.
Show me the charge.
Page 46.
Show me the charge.
That is page 42, running page. 51. May I place it?
Yes. Now let me see the charge. What the charge sheet says. Yes.
Yes. Page 51.
Yes. And the
6.
51.
Madam.
You read it out.
6. Dr. Haraprasad Mishra was working as a ADM of Keonjhar, were also drawing and dispersing authority of the said office for the period 8/4/13 to 30/11/13. See, Paresh Kumar Das was working as the head clerk of the said office from 30/12 to 2015. The then head clerk, Sri Das, had prepared the pay bill for the month of March 2013 to June 2013, and then DDO, present petitioner, was drawing up the salary bill without grant of leave or receiving working certificate of the absent period March 2013 to June. In absence of a working certificate that has been granted. You should not have. And another aspect is
that amount of disbursement.
ଦେଖନ୍ତୁ 8/4/2013 30/11/2013 he was in charge. And last table he was granted salary in respect of March, April, May, June, and year due from January 13 to April 13. He could have done that. ଆଗରୁ ମଧ୍ୟ ତାର salary ବନ୍ଦ କରାଯାଇଛି, କିନ୍ତୁ they all doctors reviews have released their salary to the tune of lakhs. Without that person has never worked since 2009 to 2013.
Yes, sir. What do you?
Kindly see that let me place the FIR.
Yes.
What is the allegation against me? So far as my allegation relating to my period is concerned, your mercy will find it. 2013 Lord. It was charge sheet.
In the FIR, your name was there? FIR that.
FIR is case 17. It has it begins
20.
It begins with 14. No? Begins to kind
Begins from 14 ends at 20.
FIR was there. Well, the FIR your lordship will kindly see that I am Lord. Mishra.
Yes.
It's more than that.
I think you should argue all these things at the stage of framing up charges.
No, he has come against
Discharge. Okay, discharge. Okay.
no, the case is, let me explain. This prosecution case is that it has not, prosecution case is that the working certificate has been received in my office. That is not the thing.
So that's what I asked, whether working certificate is issued which is false certificate. Is it not your responsibility to verify? Being dispensing authority. You can rely on anything in that. And you have not only given the salary from March to June, areas from January to April.
That fact is not correct. Come. On their own statement recorded under 161 and others, it is there. Otherwise, I would not have been placed with that. But I would say that is it their case that certificate has been
No, their case is with the working certificate, those certificates are false.
False means
You are not false, therefore 120.
no. Who has found that it is not false certificate. It is a false certificate. That's what can we see. That person has prepared the working certificate.
Right. Therefore, 468, 471 against him.
If you have given a false certificate, then it is his responsibility. But if they, on the basis of that certificate, the bills are prepared and put on the their approval after having been checked by the office, how is it that the head of the department going to scrutinize everything?
That is the reason I wanted to know the rule of business. Let us understand what is the function. And the senior, it is kind of a vicarious liability. You are the head of the office. You have to owe the responsibility.
And
You are the head of the office.
Everything is happening and you are yes. Accountant, how it is done, but as far as my knowledge goes, accountant takes the deal. Then the superintendent of that section verifies the deal and then places it for approval. It is not possible to check up every item and whether it has been signed by any.
The problem is 120B, whether there was a knowledge, whether knowledge is there or not, everything has to be reduced in the evidence only. Today, by reading the charge sheet, I can't form an opinion that you are the disbursing officer, you didn't have an idea. You acted upon the document placed before you. I can't form an opinion on that.
Your lordship is that the charge sheet is contrary.
Because you have been charged under 120B only.
Charge sheet is contrary to the statement in the FIR.
No, FIR may be something, but after investigation, this is found.
And also 161. Whether your lordship might look at page 16.
Sir,
1 minute.
No, 161.
I am sorry that your lordship is already vexed with me. But
It's always a pleasure to hear you. That's not any. This is 160. These are the documentary evidences. I can't read a 161 statement to evaluate the documentary evidence.
entire effort is to make a submission that the entire reading of the FIR and the police papers doesn't reveal a case against me.
What about the documents? What are the documents? These are the documents. You were working from 8/4/2013.
That is
You show 161 if you want. No problem.
can be seen the article 6, page 60.
60?
60.
Yeah. Yes, I'm there.
This Balaram Das, Balaram is supposed to have received the money, which I am supposed to have passed, madam. Item number 5, your lordship may kindly see.
Yes.
Original working certificate of Dr. Balaram Das J.D. Malda, by letter number such and such, containing 46. Then, Lord, your lordship will see my Lord. My article C, Lord.
Yes.
Page 62.
Yes.
Personal file of Sri P.K. Das head clerk, DMO calendar containing 1 sheet in note sheet side and 45 sheets in corresponding side. Personal file of John Sachin Junior Clerk, there they prepared, he has prepared and he has passed it. Then, my lord, your lordship sees, so far as my period is concerned, one of the statement recorded at page 64.
Yes. I'm there.
Question number 5 answer. On perusal, question number 5, on perusal of the attendance register of Bellavade GAD. That is not supposed to be. It was found that 2/12/2009, Dr. A.K. Ghana DMO had visited Bellavade and found he was absent from such and such. Further, Dr. Nirmal Chandra Mishra had visited this edition on 25/4/2010 and found he was absent. Further, you are also found absent as the varied.
What do you want to say?
Well, you have not submitted working certificate during the period noted above for trial of your salary by district AMO.
Yes.
But you have been paid salary to the
Yes.
What answer? He doesn't say that he has submitted the working certificate.
These are the oral testimonies that has to be reconciled with the document sealed.
That right.
Am I entitled to do it?
He admitted that I have signed the working certificate.
Right. I can't see, sir, in the 161 statement, I can't appreciate vis-a-vis the documents and pass a judgment discharging you.
But while filling up charges, my lord, you are lordship challenging cognizance, my lord, is a very limited scope of yes. But while evaluating a charge to find out whether a charge has been
case is made out,
then your lordship can also sift the evidence and go and find it. That is second from behind by his case.
Right.
So there is a wider scope.
But can I appreciate 161 statement?
No. I am not 161. I am telling them prima facie to satisfy your lordship that on there was a working certificate. How can I compare this whether if you have signed it, question of comparing it doesn't the right? Because I was not present there when
and wherefrom I'll infer that you had no knowledge. Wherefrom I'll infer. Unless they are subject to cross-examination of these witnesses. You wouldn't cross-examine to these questions to be put to them, whether you had a knowledge or not. See, you want to be precisely trying
that your lordship, I am not asking your lordship to evaluate.
Yes.
I am only telling that, my lord, if there is the rule is that on the basis of the working certificate for the days he has worked, the salary will be paid.
Yes.
Salary will be paid by government, only cost will be.
Right.
Then he issues working certificate. For the period which is supposed to, he has
Not worked. Yes.
one. There was no dispute that he was holding that post, which entitles him to salary if he has worked. There is no dispute that the working certificate sent has been received in my office.
Where is that working certificate soon?
That has been seized.
Where is that?
That must be with them.
Where is the working certificate soon?
You also kindly see the intention. The circumstances very clear that clearly indicate the intention. He was when he is disbursing salary in respect of March and the earlier DA in respect of January, it showed that he was put a question why this was lying, why it has not been paid. Why he put that question, then other things could have come to light. Yes. Then he showed the intention. He was deliberately not acted upon as per law. With a vigorous intention and
no, therefore you tell me when the areas were allowed, who had verified, at what stage it was verified?
It was not verified. The clock, it was the bills, and put it on so many.
Yes, that is 51 we are saying.
51.
Yes.
But we then SC Siddhas had prepared the provisions for the month of March to June, and then BDO Mishra was drawing up the salary then without grant of leave or receiving working certificate after that period. Takari state work prepare karchi this work.
Then the allegation is he is not verified.
Not verified.
Yes.
And the other aspect is he has done it intentionally. With knowledge because there is areas. In respect to 2009 his salary has been stopped. Now, say some of them these days days 51.
But is since area DA from 113 to 430.
Yes. March 13 to June 13 salary you paid, and areas from January 13 to April 13. Yes.
Area DA.
It's all right.
Area allowance.
Yes.
No, that is not salary now. Salary has already been paid. Only difference is salary.
treasury payment kala. No. January 13 to April 13. Did you and he has also he is also matter regarding him you just shown where long chalichi. You lordship kindly see that this pre-prospectus only assumption and presumption and the subjective not a pre-sale stage. Intention is a state of mind. State of mind, how should it prove? It is a matter of trial. Yes. Okay, you file, I'll pass an order. You give in. No, that's a direction to produce. You produce those things also. The certificate. You produce, I'll pass. I am satisfied that I have any way or the throat anything that I am bound to verify me. Last time I asked this question. How can I produce? The hierarchy is therefore the hierarchy is fixed. I hire the responsibility. Hire the position, hire the responsibility. That does also that this is not directly in my knowledge. That's right. But hire the post, hire the responsibility. That's right, Lord. You are the head of the I am head of my office for 6 years, Lord. That 300% were working. But am I to verify all the bills whether they are attended or not? I remember go and check out each and everybody's salary attendance. Practically, that is not possible when yes, you give documents. Give these documents. Yes, next. Judgment is order. Why are you listing hearing matter beginning to that at least? But it can be listed subsequently. Hearing matter should be the reserve it. Reserve. You give me those documents and pass your. Yes.
Yes, Your Lordship. This is an application challenging the order of convergence, Your Lordship.
Yes, madam.
Last time, Your Lordship was directed to collect 164 statement of the victim, Your Lordship.
But send letter, my CD is not. CD is not.
Everything CD. Urgent. Yes. Next.
Okay, Mr. Lordship.
3.
My lord,
Yes, sir.
this is a case of cheating
Yes.
against the principal of Varagal.
Principal of
Varagal Pharmacy College.
okay.
And
Your lordship is directed to bring all the victims with him twice for that case was adjourned.
Yes. Where are they?
victims,
Those who have filed the.
No, he is the accused. He will pay back them the money. That's what you say.
no, it is just delay issuance of certificate only.
Whether they got the certificate or
They
not,
have got my lord.
how will
I affidavits, my
no, you call them.
I affidavits.
Don't do that. At least 2-3 people should be there. Last time also agent only because of that. How do you know whether it is
Appeared in this case, my lord. Who? Advocate, my lord. Who appeared in this case? Through advocate, they filed the affidavit.
Just see the order dated 28/8/2024. Read it.
28, they are from another.
It says that the matter has been adjourned time to time for appearance of the accused and the informant. Even today, an adjournment was sought on that account. Leave the matter and so and so, so and so. It is made clear that on the next date of hearing, if the petitioner and informant shall not appear, the matter may be heard taking into consideration this aspect of the settlement and so on, so on. And again, adjournment was sought on the next date of hearing. And today you are there without informant.
My lord, informers, they all have enter appearance through their advocate, my lord. They have filed the affidavit, but they have not.
That this order was passed.
Issue notice to them.
Why issue notice? You said that settlement, you took some order, and today you are, and how many days has been SJC? Adjournment. You can't take the court granted. How do I know these affidavits are procured or not, or forcefully who signed it? How do you know? In settlement means the informant has to be there and tell me that yes, I have settled. At 2 o'clock, if you don't come, I will dismiss it. 2 o'clock.
My lord, you are some of the
No, I will not. Sir, I have accommodated you many times. I can't do it. A peremptory order was passed long back. 2 o'clock. Next. I have to be strict, otherwise the board is,
Last applicant ଥିଲା
whatever, sir, you have to bring the informant at least.
ସେ ପିଲାର ସାର୍ଟିଫିକେଟ ଅଛି ଇଏ ସେତେବେଳେ ତାର ସାର୍ଟିଫିକେଟ ଅଛି ନା
ଆମର merit ଆଗକୁ କରିବ ନା I am ready to hear.
ନାଇଁ sir ମୁଁ ସେମିତି
If you are saying settlement, then informant has to be there. Need the informant, not an advocate, some affidavit is filed, whether the affidavit is procured or not, I don't know.
sir ଏଇଠିକି ଆସି ସାର୍ଟିଫିକେଟ ନେଲେ ଏବଂ
I don't know. You bring them at 2 o'clock. Online, I am giving that facility. Let them appear online. What is the big deal about it?
Also disclosure forwarded on the offense matter.
I'll disclose that.
That is compounded, that can be compounded.
You can compound it. I'll record it. It's a compoundable. You can compound it. I'll record it. I'll record it and relegate you to the trial court. You appropriate application, it will be compounded. There also you have to appear. There also the informant has to appear. Even for compounding. Who says no? I'm not saying no.
out of date road.
No. After the detail one, otherwise there is a peremptory order. I have to respect the order of this court. At least. If I don't respect, who else will respect? I'll flout my order myself. Peremptory order was passed. Thereafter, 2 adjournments are granted. Even then, you are not coming. Why leniency? 2 o'clock you bring the informant. Online, let him appear online and just do that. Don't worry, ask him. Ask him. Yes, next. 4.
Item 4, my lord, may I pray for short adjournment, my lord? Or do we have applied for the certified copy of the?
I don't need certified copy. Come on.
My lord,
Are you, what is this matter? Let us see. 109 wife.
Yes, wife, my lord, principal accused person has been died and the case has been
That it is covered by judgment of Hon'Ble Appeals Court and this Hon'Ble Court also. And last second, the lordship had a candidate. You don't have a case at all.
No, my lord, your lordship.
What? No, how will you get out that judgment?
My lord, your lordship on the last occasion said that to bring some
See,
other.
I tell you, leniency, it's one thing is leniency.
Yes, ma'am.
8/5/2024, 3/9/2024, 6/9/2024, 20/9/2024, 8/10/2024. 1, 2, 3, 4, 5. 5 adjournments.
My lord, as the last, my lord, this matter is pending before the the file is not accessible, my lord. My lord,
I made it very clear. I will not give adjournment unless
my lord.
if there is some merit on the matter, definitely.
Yes, my lord.
There is no merit. There is no merit. You are covered by.
The police papers have not been served on NOS, my lord.
I am executing the certificate copy. I am not.
No, my lord. Not about the certified copy. We have let us procure the certified copy of the 161 statements to bring out some other materials in our
see, if you have a case on merit, I can understand. If there is no case on merit, why should the case be pending? You tell me.
My lord, as the last chance, my lord.
I will be the happiest person if something is there. I will give the.
Yes, my lord. On the last occasion, your lordship said to bring some other material, so we need to go through the 161 statements and the other documents, my lord. But we have applied for the certified copy since the court is shifting in Bhubaneswar, so the file is not traceable since long, my lord. Lord, may kindly visualize.
See, on 6/9/2024,
yes, my lord.
You read the order. It says, Mr. Roy, learned counsel for the petitioner seeks for an adjournment in order to examine the judgment cited by Mr. Maharana, learned standing counsel for vigilance.
Yes, my lord, I bow down, my lord, my lord.
You argued the matter. The judgment was cited. I said that you don't have a case covered by this case. Then you say adjournment.
No, my lord.
Thereafter what happens? When the matter is taken up the next date of hearing on 20th of September, you sought an adjournment. And what thereafter what happened? 8/10/2000 again adjournment. Yes, my lord. Now again.
My lord, we are unable to procure the certificate.
Pay 5,000 to the bar.
Burial shift.
Adjournment 5,000 to the bar. Yes.
No, my lord.
Adjournment subject to 5,000 rupees.
My lord, as a last chance, my lord, a week's time, my lord. My lord, after that, we will, as well also please, my lord. But this time, my lord,
5,000 to the bar. Next. 5,000 to the bar.
My lord, please, man.
I'll write a detailed order. Don't worry.
6. Pardon, your lordship.
You are young man. Why can't you read it?
My lord, you
take it as granted that this court will not want you.
My lord, I have read the brief, my lord. My lord, we have only.
You read the brief, you came to know that you don't have a case.
No,
so therefore you asked me for it.
Your lordship has said on the last occasion.
No, young men are not allowed to. Sir, the last adjournment, I will like this.
Lordship will be assisting your
Lordship may say that on the next date he himself will argue the case. Let him get ready and he himself will argue.
Next week, put it on 19th. 19th. Put in the 19th. 20th. And it's made clear that tell your full name. Mr. Tarini Prasad Tripathi is seeking adjournment, once again adjournment in this matter, and undertakes that he would himself argue on 20th of this month. Leave the matter on, sir. I will not allow anyone to argue. You come and argue. Okay. Sir, I rescue you. Otherwise, you would have made
Pardon me, your lordship. Item number 5, your lordship, my learned friend took adjournment, your lordship, that matter we took instruction and permitted to withdraw, your lordship. Item number 5, your lordship.
Who is taking adjournment?
My learned friend, one of my learned friend mentioned he took the adjournment.
Permitted to withdraw, yes.
Well, reporting I was given to raise all the point.
Liberty is always there.
Yes.
Liberty is granted to raise all the points before the trial court at appropriate stage. Yes. 6, sir. Yes.
That's it. The matter pertains to a case of disproportionate assets,
Yes.
wherein the husband of the petitioner is the principal accused. Possession of disproportionate assets. He is the wife, and in the charge sheet, the occupation of the wife has been mentioned as housewife.
Yes.
Doing nothing.
Yes.
And the charge sheet further mentions that during investigation, the investigating agency found that there were income tax returns in the name of the wife, the petitioner. And they instructed the husband of the petitioner to furnish the documents in regard to the business as was claimed. It was claimed that there is dairy business and poultry business, and the documents, the charge sheet says that they could not produce any document, they did not produce any document, and further it speaks that the husband of the petitioner had not obtained any permission of the government for doing business by his wife. And accordingly, on these grounds, the business were not believed. And the income of the wife was not believed, and she has been shown as a housewife. My humble submission herein is that, Lordship,
have you put forth any separate defense yourself?
No defense.
Okay.
No defense. So, as per their case, as the wife had no income, so we are covered by your Lordship's decision.
She is filing income tax returns since long and claiming that his income from house rent, dairy farm, poultry farm, business, etc.
But they don't say, Lordship, they don't say that the income tax returns are
Every filing itself, see, distinction is whether she is putting forth, trying to justify the
she has claimed that I have sources of income from this and this.
Let them show that.
She has contributed anything to the husband, and she said,
No, that is not necessary. I will show the judgment. If he's a housewife, arbitrarily if she is saying that she is a housewife or having no sources of income and filing income tax returns, and thereby she has intentionally aided her husband in covering the ill-gotten money. I'll show the judgment of this honorable court.
Let him show. My point my point herein is that, Lordship, he could not understand my point. My point herein is that I am not saying that I am a simple housewife. There are income tax returns. My only submission here is that the Vigilance Department has not rejected my income, has not been there that the income came is false. They are not stating that. What they are stating is that since I could not produce the documents relating to the vigilance, and since my husband has not taken permission for doing business by me, that is why my income is disability. Then what long they are stand? And on this basis, they say that I am simply a housewife. Now, Lordship, the decisions which were relied by Lordship in giving that decision, wherein the proceeding against the wife was passed, therein Lordship relied on Nolamal and another case, wherein the question was the property was Benami in the name of somebody else. Wherein the property is in the name of the wife, which is very natural. And in our society, it will not construed as Benami. If the property is in the name of the wife, it will be construed. What is the argument that it would be in husband?
What is, and you will also kindly see page 43. Serial number 3, movable property, 5, 6, 7, 9, 10, 15, 16, 17, 18, then movable assets, gold and silver, then bank deposits. Everything is in the name of the petitioner.
No, everything then
then who will explain? The Vigilance Department will explain. This is the law. And the law, my law and senior is miscomplimenting all the state, is misinterpreting the law, later also. Another case is not referring to that, that is not the case here.
Yes.
And the Paris case is referred, they are the mother of the pension holder and her income is sufficiently high, then the assets procured in the name of
yes. Bro, kilo hai case. Yes. More case, Saita. Lordship, one thing may I request, he is required to produce those things, those judgments, and to argue. And in the meantime, as the petitioner has already appeared before the learned lower court and some months have passed hereby, may I take an instruction as to whether she has filed an application for discharge before the learned trial court?
Okay, yeah, I'm simply,
And Lordship, I will call it on, may I request Lordship to call it on 7th of next month?
I'm simply issuing notice to come with this. Meanwhile, you,
Lordship.
7th, issue notice, yes.
From 7.
May I please your lordship?
Yes.
The order under Annexure 3 is under challenge, your lordship.
Annexure 3.
Annexure 3, your
Yes.
Here, your lordship, the cognizance was taken by the Leonard JMFC, arising out of the 1cc case, your lordship, against the petitioners. Here, your lordship, there is a plea of LEV also here, your lordship. It's a plea of LEV. Because the petition number 1 is the police officer, your lordship. At present, he is working as ASI, the Forest Department.
Well, how many accused persons are there? 8. All of them are enemy.
No, only one. Then I challenging the place of occurrence and time of occurrence, your lordship.
No, but there are 8 prisoners.
8 prisoners. The case was initiated by opposite party number 2 on the same day of occurrence, which was taken place, and they asserted my mother. The opposite party number 6 and the opposite party petition number 6 lodged an FIR on 30th 8. Thereafter, after less of 3 months, on the same cause of action, again this 1cc case was initiated by before the Leonard Court below, and accordingly, even though they submitted all the FIRs and the documents, and there is also two civil suits are pending against both the party. But this
What are the allegations? You tell.
allegations?
Show me the 200 complaint.
My complaint question I will next
Yes.
lordship.
Yes.
That is 30 page number.
What are the allegations?
Allegation, your lordship, you have taken. In the application, there is a section they mentioned 294, 391, 320. Of occurrences.
What are the allegations?
Allegation is valid on the date, the lordship 40, page 40. Many social and cultural ceremonies public.
Are they related?
D.
Are they related?
tag. No, D tag. 70,000 for their illegal gain causing for that he is not the affair. No. My lord, kindly peruse.
Issue notice, let us see if can. Allegations are
Issue notice.
And what is the service position, Justice?
My lord.
Service position.
Issue notice issued on 21/6 your lordship.
Service position.
21/6/2024 notice issue.
तो किसी देखो
for order ଅଛି
Service position, you just check it up and keep it ready. Notice issue 21/6/2024.
and I have
No. Notice is not issued. Just extra copy to be filed and notice was not issued. Opposite party number 2 is there. Right, notice was not issued.
but I would already deposited the
issue notice to opposite party number 2, returnable next after 2 weeks. The interim order pass on 21/6/2024. Shall continue till the next date of hearing. Requisite to your file. Requisite already filed shall be utilized for the purpose of service on respondent number. Yes.
on letter. I filed on letter.
It's all right. They'll find it. Yes, next.
On the same day of occurrence that case was the case.
Extra copy, you give one more extra copy. You might not have got it. Yes, next. Yes, madam.
Yes, Lordship.
Yes.
Lordship, this application has been filed for seeking commencement of the criminal proceeding, Lordship.
Yes.
Lordship, allegation is that I am the bank employee and there was some wrong transfer of funds, Lordship. And amount paid by the bank differ from the amount for which they were done, Lordship. And that amount has already been deposited.
Yes.
And Lordship, I am challenging this in 2 grounds. That is on inordinate delay of proceeding and Lordship, in a disciplinary proceeding, Lordship, the punishment of removal was converted to some minor penalty.
What is the stage now?
Your lordship say. Your lordship for a moment, your lordship may kindly see the prayer, my lord.
Yes.
Initially he has approved and that was disposed of, but in your part he has not reflected. Thereafter your lordship for a moment pays 6 minor.
P6.
That is the prayer, my lord.
Yes.
Therefore, LCR may be called for
Quashing the criminal.
then my lord ground, your lordship may kindly see the ground at page 4, paragraph 4.
Yes.
You stated that no witness has been examined. Lordship got it. Then your lordship will kindly see at page 35. Order dated 23/2024.
Yes.
4 charge sheeted these are present and they are examined, cross-examined. So trial is going on.
My humble submission is that typography.
Once trial has been commenced, my lord.
It is already trial is commenced. 2013 charge sheet is filed. Today you are coming and asking for quashing. I'll scuttle the trial at this stage. How can it be?
Lordship, my humble submission. Lordship, kindly glance. Page number 30, Lordship.
30. 30?
Well, Lordship, that is.
I'll expedite the trial.
Well,
I'll expedite the trial. Right up. Petitioner is an accused in Malkanagiri and Kalimila, PS case number 41 of 2012. The FIR was registered on 22/6/2012. And after investigation, charge sheet was filed in the present case on 11/3/2013. After the trial has already commenced in the present case. 4 witnesses have already been examined by the prosecutor. By the this is prosecution state case, huh? 4 witnesses have already been examined. 6 witnesses. 6 witnesses. Where is that? Where is that?
That is my case and discharge schedule 3 to 6.
Page.
That order is 35/23/2024.
Page, sir. Page.
Sir. 35, your lordships.
35, huh?
Page 35, order dated 23/2020.
Yes. Order date
23/2020.
4 witnesses, na? It's 4
Class election, the discharge and schedule 3 to 6 respectively.
The 6 witnesses have already been examined in the present case. So, therefore, in the midst of the trial, I am not inclined to entertain the prayer made by the petitioner for quashing the entire criminal prosecution. However, regarding head to the fact that the FIR is registered way back in 2012 and charge sheet has been filed in 2013, the trial is not proceeding at the expected pace. Hence, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible. Yes, next.
There are 21 charge sheeted witnesses.
Counsel for the petitioner submits that there are 21 charge sheeted witnesses, and therefore she appears that the trial will further prolong. Properly close regarding head to counsel and yes.
Oh, nice.
Next. 12.
Yes, sir. My lord, in spite of my repeated direction of this honorable court, no instruction has yet been received till that.
Instruction for law 690C.
Again, what do I say? The fact is like this, my lord. The allegation, the affair was lodged on 27 February 2024 on the occurrence dated November 2023. After 3 months, affair was filed.
Yes.
And the allegation was that, my lord, there's under section 376 and other 6 matter is there.
373 there. 73 is there. 15 years and affair classing.
Again, remember,
Yes,
yes, still actually Oxford is not applicable. It is more than 16. The college going to girls. Both are the students.
1 minute.
Our record, there is no.
What is the stage of investigation?
When the candlestick para 7 of my previous. Only that para is sufficient.
Yes.
The victim girl, Pastanjali Hima Bindu, had reported to the investigation officer about the incident 26/12/2023. The incident. After the statement recorded in investigation, no evidence was available. Against the petitioner for which the same investigation did not fail to charge sheet and FI against the petitioner. In view of such efforts and allegations, not mentioned as of law. That is a no record, nothing. They will file the final. Nothing is there. Then they will file the final form. How can I interfere? I am a student. I am unable to
What's the name? See the FIR. When the FIR was registered?
FIR dated 27/2/2024.
Then
incident 26
maybe petitioner is in this petition seeking quashing of the FIR Paralakimundi previous case number 57 of 2024 registered on 27/2/2024. The allegation, the petitioner, counsel for the petitioner submits that despite to the FIR was registered in the month of February, charge sheet has not yet been filed. It is not because the police is not able to gather any evidence at all. He has pointed out to the contention he raised in para 7 of his petition, which reads as under page 4, page 4, para 7. On the basis of the aforementioned environments and ever mentioned the grounds, he seeks indulgence of this court. I am not inclined to entertain this petition at this stage because investigation is still going on. At the same time, the apprehension of the petitioner is well founded. The petitioner, the police is expected to conclude the investigation as expeditiously as possible. With this observation, petitioner is disposed of. Next.
A time limit given.
I can't give that time. That's not the law. Yes. Yes. Next.
Time limit.
Next.
May I please? Time limit.
Time I can't give, sir, and 482, I can't bound down the police like that. Let them, they will file a closure report if you want.
Yes. The order had annexed 1 is under challenge, my lord.
Yes.
Fact of the case is like this, my lord. The FIR, there has been a law under section 498A, 294, 324, 506, 34 IPC that is filed annexed to this petition, my lord.
Yes.
Then thereafter, that is on 14/1/19, my lord. Then thereafter, the charge sheet was submitted on 19/6/19 on the subset offense, my lord. Then thereafter, after due inquiry, after due investigation, then thereafter, all of a sudden, a petition was filed with a view to incorporate section 406 IPC. We kindly see the prayer at page 29.
Now, what happened to in this impin order? What had you moved application form?
So far as then I have filed objection to
only 406.
My lord. Only
Charge is
406.
framed again 406.
Not obliged to that.
You are agreed by that.
I am there before your lordship to that extent.
Only 406. And which has been turned down.
My lord.
And you file a revision petition.
Not obliged to that extent.
I will issue notice because it is the matrimonial dispute. Now, why have you not implemented the informant? 498 case.
Yes, I will say sorry to that extent.
Is it matrimonial?
Sorry to that extent that I will implement. I will implement. Just now I am implementing the law subject to permission, my lord.
Then counsel for the petitioner seeks to impede the informant in the present case is opposite party number 2. He may do so during the course of the day.
Just now I am with permission.
Not here, all during the course of right now you do. Once the opposite party number 2 is implemented, as opposite informant is included in the opposite party number 2, issue notice to the newly included opposite party number 2, written within so on. Yes.
So for that,
I can't because you file a incomplete petition.
And there is no illegality in the order, mine. Because
I have seen it. I am issuing notice because the matrimonial dispute will settle it unnecessary. Let move after 2 weeks. After 2 weeks. Next.
240.
Yes.
Well, 14 I am appearing. I am only submit that I require 1 week's time. Let it be come after 1 week, my lord. That is
Why? What have you challenged by the way?
My lord, we have challenged that that it doesn't constitute a demand, my lord, because we have received. They said we have received a blank check. So that's whether the blank check given to the accused it constitute a demand or not. That has to be adjudicated, my lord. That is the only point of
bribe he gave blank check. He has given him bribe.
A blank check, my lord, where 20,000
You
was there.
prosecuted him in 138. You prosecuted in 138. You face this.
I have not encased. I have not encased it, my lord, anywhere. My lord, the only that point, my lord, I am agitating. I require some time. I have done some research, my lord. I'll come out with the decision. If otherwise, we'll.
It is not expected from you. You should argue the matter.
I'll argue it. I'll definitely argue.
You are well prepared. Why don't you argue?
Because today, my lord, I am little bit in a different position, my lord. That's the
Okay,
reason I am not able to argue today. My lord, definitely.
December last. Okay.
My lordship, in this matter, I am through VC lordship.
Yes.
My lords, by this 482 petition, I have challenged the order dated 13 March 2018, by which the
Lordship says that in February 2008.
Yes, lordship. Lordship, the extension application order was passed by lordship.
Lordship says directed to reply affidavit, instruction reply. It is not because we have, your lordship knows this from, that order is also not reflected in the.
Mr. General, for the petition, Madam submits that he could not file the reply affidavit as yet and 6 weeks time leaves the matter in December. Yes.
My lordship, please
Let
sort
me
it.
file. There is a change of guard. You have seen it.
Lordship, last date the same argument was raised.
But the last opportunity. This is last opportunity.
My
Again,
lords.
last opportunity.
My lords,
Yes.
I'm obliged, lordship, deeply obliged.
May I please your lordship? The quashing of proceeding, that is 130 NI Act matter, my lord, filed by the present opposite party against the petition on the ground, my lord, the statutory notice and not served on the present petitioner. Apart from that, 130 application not filed in time. Page 14, my lord.
No, show me the complaint copies.
Complaint copy, my lord. Annexure 1, and your lordship kindly page 14, the deposition of the deposition of the complainant.
The complaint has said that notice was issued. No?
Page, my lord, page 14, my lord. I cannot say the exact date when the advocate sent the notice to the.
Come to page 8.
My lord.
Last 3 lines.
My lord.
He says that he is
on 16 complaint sent on 16/8/2018, the complaint sent the demand notice through advocate so and so to the person through STOAD. Though the 1 month already been elapsed in the meantime, the accused person has not served with the notice, has been served with the notice, no step has been taken. He in the complaint, my lord, but in the evidence, my lord, lordship kindly see.
Yes.
Page 14.
14. Yes.
Serial number 17. I cannot say the exact date when the advocate sent the notice to the accused. I cannot show any documents showing the advocate notice issued to the.
It's all right, all right. One minute, averment made in the complaint. Evidence is contrary to the government, okay? The evidence has to be appreciated by the trial court, not in 482 proceeding. I can't scuttle like this.
Apart from that, my lord, one line, my lord. Not in time, even after file after 30 days, my lord. Even
those things, trial court will look into it. I'll expedite the trial. Right now, petitioner
with that observation, your lordship.
Yes, yes. Petitioner is seeking quashing of the entire prosecution initiated by the opposite party in ICC case number 23 of 218, initiated for alleged offences punishable under section 138(9). Then counsel for the petitioner submits that the statutory notice under section 138(9) Act has not been served upon him. Shared upon him. I peruse the averment made in the complaint petition. The complainant, opposite party number 1, has categorically stated in the complaint that the notice was sent through his advocate, Mr. M.R. Bhunjo, on 16/8/2018. Despite service of the notice, the present petitioner has not made good the payment. Hence, he has filed the complaint. However, a reading of the evidence for this complainant reveals a different story. Therefore, the petitioner seeks indulgence of this court. I am not inclined to interfere in this matter because the trial is in the process. This court, while exercising jurisdiction under 482 CRPC, cannot scuttle the ongoing trial. And in between hence the petition is petition doesn't deserve merit, accordingly dismissed since the statute provides stipulation in stipulated time for the purpose of conclusion of the trial in offences under 138(9). It is expected that the trial court should be able to see that the trial is concluded as expeditiously as possible.
Only say dispose of, man.
Disclosure, yes.
Yes. May please, Your Lordship. My lord, here the petitioner is challenging the order dated 18/7/2024, passed by the learned JMFC Telkoi. My lord, the relevant page is, my lord, on page 25. 25, my lord.
Okay.
Here is, my lord, a drug was released, my lord, with certain condition. So which condition cannot be complied, my lord? Kindly have the glass to the running page 25, my lord.
Yes.
The conditions, my lord.
You are agreed by the condition?
Yes, ma'am.
Yes, which condition?
My lord, condition number 2, number 3.
Renewing the bond.
Yes, ma'am. 30,000.
Petitions and furnish cash security 10,000.
Lakhs.
4 lakhs.
Yes, madam.
Next
And
one.
thereafter, another 6 petitions have paid 50,000 to concerned IO. These conditions, my lord, conditions which cannot be complied, my lord.
What are the offences?
A drop was
379, 411, 307, 186, 120B, 11 of prevention of cruelty to animal.
Cruelty to animal.
Guy by negligence for that reason.
But why should we pay 50,000 rupees to the IO?
Yeah.
This is not required, but this is under Rule 5, you would pay. 4 lakh you would pay.
And that
4 lakh and also indemnity.
Indemnity bond, yes.
Yes, I am ready to pay the indemnity bond, my lord. But my lord,
then who will bear the expenses of the cattle which you are smuggling?
my lord, trial, my lord,
That is the rule what to do. Read the rule. Read my judgment.
Yes, my lord.
You read my judgment. Very detailed judgment I agree with in this subject.
ଏଇଟା ବି 6ଟା ଯୋଉ ଲେଖିଛନ୍ତି କାହିଁକି explain ନା to meet his expenditures for transportation, labor, etc.
Kindly identify my
No. You are directly against the judgment of this court. What to do? You deposit 2 lakh rupees and the rest of amount you move application there. Let him deposit. Petitioner is agreed by the condition imposed by the court below, condition imposed by the JMFC Telkoi, while allowing the application of the petitioner under section 457 CRPC for releasing of the vehicle, which is that vehicle? Truck, releasing of the truck seized while seized in relation to FIR number so. FIR number in relation to Telkoi PS case number 143 of 2024 for alleged offences punishable under section 379, 411, 307, 166, 120B, 11 bracket 1 bracket A of prevention of cruelty to animals, bracket 2A 1990. The learned counsel for the petitioner submits that the direction of the trial court to deposit rupees 4 lakhs and the direction to pay 50,000 rupees to the IO of the case is harsh and he is not in a position to make good the said payment, hence this petition. Judgment of the case of the petitioner, the
6 ଟା ରହିବ as per your lordship 6 ଟା ରହିବ କାରଣ ସେ ତା pocket ରୁ ହେଠୁ transfer
I know that I have written judgment in view of the judgment of this court passed in so they know cruelty against animals or the judgment each one. Now pass, I am not inclined to allow the present petition. However, however, liberty is granted to the petitioner to move appropriate application before the trial court for variation of the conditions subject to the petitioner making at least a deposit of 2 lakh rupees to begin with. If the petitioner move such application and by depositing 2 lakh rupees to begin with, the trial court may consider the application. Shall consider the application and if think deem fit and proper, may modify the condition. With this observation, this program. Yes.
18. That is also, my lord, same.
Yes.
Same, my lord, same order.
Same order. 18. 18. What is the condition? Condition here?
Condition is same.
4 lakhs. 4 lakhs.
Yes.
4
4 lakhs and 50,000.
However, the condition for depositing 50,000 rupees with the IO of Cheptol police station is waived. That would be 50,000 you need not pay. When so far as 4 lakhs is concerned, you deposit 2 lakh rupees and no application.
50,000 he has spent for that transportation to Gosala. That is the order, my lord.
Spend.
My lord. They have reflected.
So, from his pocket.
From his pocket. So, for that reason, the court, after ascertaining that, has passed that order.
Where is that?
That is 25 pages.
30. Yes.
The orders are ready. That paragraph 25 paragraph condition 3, 4, 5, 6 my lord. The petitioner shall pay some appropriate to the concerned IO in the employee PS case number so and so to meet his expenditure towards transportation, labor etc. which he had paid spent from.
How many caterers involved? 105 caterers.
50.
The
proceeds may pay one thing. That 2 lakhs let him he release and 2 lakhs will pay subsequently because 4 lakhs is not a paid prop manner.
I know. 2 lakhs let him pay, then have application and variation.
My lord.
Yes.
4 lakh 2 lakh
Yes.
Just
Yes, 18 over. Next. 19. See the judgment. If you read that judgment, you are not entitled to any leave. I am just saying that pay 2 lakh, move an application, and the court will decide on the basis of the judgment. 50,000, I guess. Yes. 19.
Original order is not there, my lord. Original order is
19.
Yes, my lord. That is so far as the annexer 1, which has been issued by the concerned police, saying that to hand over the block in question to the annexer 5.
You are agreed by annexer 5.
Yes. Now, annexer, in response to annexer 5, the proc was released in my favor. Accordingly, I am in custody. Then thereafter, the OP number 1 and 2 filed revision before the session judge, which is annexer 7 in this petition. Then thereafter, direction order on the basis of the same, police intimated in pursuance to annexer 1 to hand over the truck to immediately my daughter. So my respect to submission before this order that the petitioner is the voice of one Fakir Mohammed, my lord.
The trial court allowed your application.
Not so
bad. The Indian court reversed it.
Not
yes.
The trial court judgment is not there.
That
where is the trial court judgment?
This is the simple order which has been given to that extent.
No, it's not simple.
Kindly see at page 15.
Yes, I'm there. I'm there.
Got it, my lord?
Yes.
This is the order. That's why I have also intimated to the counsel for the trial court. That's it. This is the order. To that extent, I will close.
This is the order.
This is the extract. Extract or passed in discussion number so and so, rated so and 3 by SDM Junction. And the dictated signature is there, my lord.
But there is no reasoning that
so this is the position, my lord, that they have.
No, there must be because your lordship may kindly see extract of the order passed in miscase number.
Yes, my lord. In response to this order,
this is the extract means what? Where is the detailed order?
The order I have already.
And what is the statement there, my lord? And why?
What kind of order is this?
My lord,
what kind? This is nothing. It is a formality if you leave it here.
I have immediately intimated the position. They have said like.
Get that order at least.
I found it before filing, I have intimated, this is the thing they have intimated to me. That's why I have enclosed. Otherwise not, I would not have enclosed.
I understand you may not have.
Permission to that extent, NCR can be called for to that extent to.
No.
For the information I have enclosed. That does not mean that I have not posed the question to the council on the trial court.
Are you making a statement that except this order, nothing is there on record?
As for the information, sure, what I.
It's very difficult.
This is the difficult.
You appear for certified copy.
Now this is the position, my lord. In response to Annexure 1, police is threatening to hand over, my lord. That are talking question. Fact of the case before this, I want to draw your attention. After the death of my husband, my lord, I am the wife before lordship, my lord. 3 vehicles are of the husband, my lord. 2 vehicles are with the father-in-law and mother-in-law.
I issue notice, file the order. The council undertakes to file the order dated 30th November 2022, passed by Lieutenant STGM Jagatsinghpur of my next date of hearing. Issue notice to opposite party number 2. Yes. Mr. Jana accept, no, there is no opposite. Mr. Jana.
Opposite party to hobar bhai hai na initially sort by initially the case nothing
opposite party is there. Mr. Jana accept notice for opposite party number 2, 3 and 4. Issue notice to opposite party number 1 and 2. Returnable next week. Yes. Issue notice and then what to do?
One person has applied for release of the vehicle. Then subsequently another person came to the regional court and stated that this vehicle is not belongs to him, that this belongs to him.
That's right, but there was an order earlier. It was reverse. Reversal order. I'll just stay. Stay the impugn order dated. Stay the operation of the impugn order dated. So it is made clear that if steps are not taken by the petitioner by within 2 days to serve the opposite party number 2 and 1 and 2, the stay granted by this court today shall be automatically vacated. Pass off. Yes. Which one? 95. Proceeding on the ground of comfort. Last question, your lordship asks me to examine the judgment passed by Honorable Apex Court on November 7th. There is the judgment copy for your lord. Yes. Yes. Here 2 issues has been framed, my lord. And para 6 of the judgment, man. Para 6. 6. Yes. Here 2 issues have been framed. Second issue is relevant to this matter. Whether the power to cause a criminal proceeding complaint in regard to the heinous serious offences that will serious effect in society is mainly and because yes. That has been read in para 23. 23. Yes. Yes. What does it say? Yes, read it. We will now consider the second question as to whether the power to quash criminal proceedings invoking the power under section 482 CRPC be exercisable solely by relying on the fact that yes. Yes. Second. Para 24, ma'am. Yes. Decision of this court in Gyan Singh's case Supra itself would reveal the legal position in regard to the said question. The learned amicus curiae drew our attention to para 48, 57, 58 and 61 of the said decision. 48, my lord. Yeah.
While parting with this part, it appears necessary to add that the settlement or compromise must satisfy the conscience of this court. The settlement must be just and fair besides being free from the undue pressure. The court must examine the cases of weaker and vulnerable victims with necessary caution. Quashing of offense or criminal proceedings on the ground of settlement between an offender and the victim is not the same thing as compounding of offense. They are different and not interchangeable. Strictly speaking, the power of compounding of offences given to the court under Section 320 is materially different from the quashing of criminal proceeding by the High Court in exercise of its inherent jurisdiction. In compounding of offences, power of a criminal court is circumscribed by the provisions contained in Section 320, and the court is guided solely and squarely thereby, while on the other hand, the formation of opinion by High Court for quashing a criminal offence or criminal proceeding or criminal complaint is guided by the material on record as to whether the ends of justice would justify such exercise of power. The ultimate consequence may be acquittal or dismissal of indictment. For the High Court process a criminal proceeding having regard to the fact that the dispute between the offender and the victim has been settled, although the offences are not compounded. 29, para 29. My God. Read the para 20. Read para 20. Yes, my God. It is relevant to the contextual. It is also relevant to refer a three-judge bench decision of this court, State of MP versus Lakshminarayan. This court held that whether an FIR is quashable or not would be depend upon the facts and circumstances of each case. And while considering that question, the court has to apply its mind to whether the crime is one against the society or against an individual alone. Nature of the dispute. Second, seriousness and how the crime was committed. Whether offences is one under a special statute. Stage of proceeding and how the accused managed to compromise with the complainant. Yes, ma'am. In this regard, it is relevant to note that the case on hand victim was then a student of class 11 in the higher secondary aged 16 years. The statement annexed to the FIR of the complainant with the fourth respondent itself would reveal that on 8/1/22 he complained about the pressure from the third respondent to restrain him from lodging report. The compromise was entered immediately thereafter on 31/1/22. Despite the said position, the court has not. Yes, ratio descending is 32. Para 32. Yes, yes, ma'am. Yes, tell me the case in your case, madam. Yes. If the parties have decided to marry, my lord, and they have already solemnized the. Yes, what is the age of the boy? Boy is 18. 18. Girl is also 18. Yes, my lord. Yes. Now it is 18. 16 years old. But the father has shown an affidavit. She has and he is present, she is present virtually, my lord. Where is it? I'll take at 2 o'clock, verify it and tell you. Yes. What are the engineering and all. Yes, next. 21.
Item number 20. Huh? Item number 20.
Password, yes. 21, yes.
Lord, there is a matter fixed that would not be able to place, my lord.
20, you take it. 20, okay. Yes. Yes, ma'am.
Lord, petitioner challenging the order of cognizance dated 17/11/2023.
Yes.
And it's offense relating to 51A, 51 of OMC rule and other offenses that 447, 379,
Yes.
511, 120B of the IPC. My lord, in this case, the petitioner is the owner of that sand quarry, but the IAC lost the effect of against the petitioner. Petitioner were.
Show me the charge sheet, madam.
My lord.
Show me the charge sheet. Which page?
Charge sheet is annexure 2, my lord.
Where is that? And yes. What are the allegations?
Allegation is
Okay.
the petitioner. Both the petitioner and the owner of the land, but the charge sheet has been filed against them on offense under section 447, 379, 511, 120B, and 51 of the OMC rules.
What is your case?
Lord, the case is that petitioners are not liable for this offense as they are the owner of this land coal quarry.
What does it see the allegation? You are
It's committing coal from their own land, but the police party lost the FIR against them.
Read the page, come to page 30.
Page?
30.
And I have annexed the ROR of that land, which is name in the...
That needs to be proved on record.
Right, my lord. They are the rights.
ROR, the title cannot be proved on the basis of ROR.
My lord. These plots belong to the petitioner where the charge sheet has been filed. And in the brief fact of the charge sheet, this plot belongs to the right and petitioner is the owner of that right.
Read page 30.
My lord. During the course of...
All these things are taken note of.
During the course of investigation, I visited the spot, examined the complaint victim and witnesses, and recorded their statement under section 161, who will prove the occurrence. Arrest of the accused Manas Samal, son of such and such, district Dhenkanal, forwarded to the court, contacted to the RTO Dhenkanal regarding the ownership of the involved JCB having checklist number so and so. And it came to the light that the one Pradeep Kumar Naik, son of such and such, district Dhenkanal, is the owner of the vehicle, noted seized the vehicle agreement paper in non-judicial stamp paper by number such and such by the witness Pradeep Kumar Naik in the presence of witness C. N. Sethi IAC Motang PS serving this case the local, and I attended this supervision and obtained the S note. The SO opined that this is found to be true case under section 447, 479, 511, 120B, 34,
Yes.
did with 51.
All these things are taken note of and cognizance is being taken.
But at the time of cognizance, they have not taken into
I can't go into the veracity of these documents at this stage. I can't go into. You have to, argue all these points. How will I see whether what is the document and what veracity you argue?
At the time,
Petitioner has challenged the order dated 17/11/2023 passed by learned JMFC cognizance taking Dhenkanal in GR case number 246 of 2023, whereby cognizance of offences punishable under section. Where is that cognizance order?
Cognizance order is at Annex 6 manner.
Punishable under section. Annex section under section 447, 379, 511, 120B, oblique 34, IPC. Read with section 51 of OMMC rule is taken against him. Against them. Let counsel for the petitioner submits by relying upon the series of ROR placed on record, submits that in fact the present petitioners are the owner of the land in which the excavation was carried out. So therefore, no case against them is made out. Hence, he questions the cognizance order. I'm afraid at this stage of cognizance, this court can go into the veracity of the documents relied upon the petitioner and appreciate the same. Therefore, the petitioner the petition has no merits. Hence, the same is dismissed. But dismissal of the petition shall not preclude the petitioner to urge all the points before the court below at appropriate stage with this observation, the petition is disposed of. Yes, next.
21.
Let's see on behalf of Hemant Mahant. Kindly pass over. Okay.
22.
My lord, I am the case of appearing on behalf of petitioner husband. This case arose out of matrimonial disputes. The decree of divorce was granted on contest.
Okay, I will issue notice. I will issue notice to opposite party number 2, returnable also. Mr. Also accept notice of the state. Release the matter on circumstances state. In the internal petitioner is at liberty to move application before the trial court for seeking an adjournment owing to the fact that the petition is presenting to be. Yes. Next.
23. My lord, one IA is there.
I have passed the order. You can move application there. Yes.
This application petitioner pays for a question of the effect. Petitioner. Also, petitioner has been implicated in this case. Investigation is going on, my lord. You won't tell everything to the police. Earlier petitioner moved before this honorable court.
Why are you coming at this stage? See, this FIR is registered in August 2024, my lord. Investigation is going on. Allegations are serious in nature.
Earlier petitioner moved before this
seeking quashing of Koliport PS case number 652 of 2024, registered on 9/8/2024. Investigation in the present for offences punishable under section found so like the section 8, page 8. The investigation in the present case is still going on. At this stage, this court is not inclined to entertain this petition, hence the same.
Earlier petition moved before the honorable court in ABN appeal number 9193 of 2000.
That's really something different, sir. Really something. Yes.
25.
Belgium matter, my lord. The warrant has been issued by the Lorna trial court dated 24/7/2024.
24/7/2024. NBW.
Yes.
Bill.
Bail. Yes. Bail matter was committed to the Court of Sessions.
Do you have a date? On the bill, when? Do you have the date? Do you have the date? Yes. 500. Yes.
26.
500 you pay. Yes.
Next week I will sir.
Not next week I allowed you.
Yes.
But
26.
The complaint lodged for the locality for certain irregularities in forest regarding low survival rate of plantation is quashed by the Honorable Court in the writ petition. And complaint was recommended 107 by the locality.
Yes.
So it was quashed 130 by this Honorable Court in the writ jurisdiction, my lord.
Yes.
Page 23. Keeping the aforesaid discussion in mind, the court is inclined to quash the order dated 18/23 past locality case number LY 543 accused and order dated 29/4/2022. It is confined to the present petitioners. LY.
Where are you reading?
Page 130. 130.
Okay.
Yes, minor. Paragraph 23. Keeping the aforesaid discussion in mind, the court is inclined to quash the order dated 18/32 locality. Yes. So, my we belong to the second category. Convey case number
540 of 19.
So, my lord, it was quashed on 19 April 2024. Right. So, before on the basis of the complaint, the locality, the cognizance is taken by the special vigilance is 11/7/22, age 133. So, if the complaint is quashed and out of the complaint and emanated, the GR case is going to be tried on the basis of the cognizance taken.
So I pray, the last,
No, what is the basis of passing of the order, final order of the local?
my lord,
What are the basis?
but the Lokayuta giving findings want across the entire,
I know what are the basis you say. You tell me. The complaint has already been filed. Cognizance is taken in 2022. In 24, the High Court passes the final order. It doesn't mean that the entire thing is washed out.
my lord, cognizance is the report was submitted on 107 on 3/4/22.
Yes.
Is 107.
I understand. It is shown the reasoning of the High Court. What is the basis of passing of the final order for the local? What is the basis? Which paragraph you want to rely upon?
My lord,
yes, Mr. Mohan, what is it?
all the proceedings resulting from the petitioners also start.
I understand you are not reading.
Was the order on the ground that provisions 21 that the report from competent authority should be obtained. Clarification, the permission from competent authority shall be.
Yes.
So it's mandatory. So would I have to take instruction whether any appeal has been prepared?
Yes, okay. Mr. Marana accept issue notice, Mr. Marana accept notice and submits that he will be seeking instruction as to whether any appeal has is already proof has been preferred against the order of the judgment of this court dated
19/4/2024.
19/4/2024 passed in WPC number 19979 of 2023 and batch. Needs matter. Yes.
May I pray?
Yes.
The proceedings may be submitted
1 minute after 1 week. Yes. Yes.
Yeah. The prosecution filed an application under section 311 CRPC. That was allowed. Against that, I filed this application.
That is allowed.
My lord.
So who is it?
I'm the accused, my lord.
The prosecution, prosecution,
my lord.
yes.
If your lordships kindly see the application filed by the prosecution side, that is annexed to page 13.
Yes.
The prosecution filed an application to call for 2 persons for evidence, my lord. If your lordship kindly see that application page 13, it is submitted that in the event noted case today has been fixed for hearing and the prosecution desire examine 2 new witnesses connected to this case. During the hearing of the case, these witnesses' name came into light through the other prosecution witnesses' deposition.
Yes.
The other witnesses who have been examined, they have
yes,
my lord, they have no order, my lord. That order is, my lord, that is annexure 3, page 18, my lord. Last paragraph, my lord. Considering the above facts and circumstances, this court is of considered view that knowledge of Lakshmidhara Naik and Rasmita Raut about the occurrence cannot be ruled out. My lord, they are not the charge-sheeted witnesses. And thereafter, they are found to be vital witnesses and their evidence is essential for just decision of the case, my lord. This court is also viewed that prosecution should be given fair opportunity to prove their case. There is no material which would show that prior to call Lakshmidhara Naik and Rasmita Raut for their examination has been made. In this case, my lord,
you are only saying that these witnesses were not named in the charge sheet, so therefore you can't be.
My lord,
we show me the legal part.
my lord,
the court should the prosecution is not named these witnesses in the charge sheets. They can't examine anyone.
my lord,
There is a court witness also. The trial. Only to see that the fact will come record. That's the idea.
my lord.
There is a legal part, should be.
There is no legal bar, but the court should have considered whether it is essential or not.
Consider this detailed order.
My lord, in the if your lordship kindly, see the paragraph, my lord, of the finding of the court that is annexed.
Come to page 18. Last paragraph only read.
My lord, my lord.
And detailed discussion is already there, but last paragraph read. Considering the offense.
Above facts and circumstances, this court is
Considering the knowledge of Lakshmidhar Naik and Rashmidhar Naik about the occurrence.
occurrence can only be resolved. If the lordship kindly see the finding of the court, my lord, that is page 16, my lord.
16, okay.
Right.
Yeah.
Sorry, my lord, sorry. I'm extremely sorry. That is page 18, my lord.
Okay.
Page 18. First paragraph, my lord.
Yes.
However, my lord, second line, my lord. However, on perusal of deposition.
It's 18, huh?
My lord.
Okay.
18. Second line, my lord.
However, on the
perusal of deposition PW3,
it is found that
Urmila Senapati is found that her deceased daughter was brought to hospital in the car of Lakshmidhar Naik, my lord.
Yes. Yes.
And thereafter, during her cross-examination at para 23, she has also stated that while her daughter told about occurrence while undergoing treatment, her friend Rashmita Raut was present. So they were only, my lord, here, my understanding before, Rashmita Raut was present. And the car of the Lakshmidhar Naik was used.
You ask this question. When it comes to the witness box, ask this question.
My lord,
You can come to the witness box and ask this question.
Lordship is correct, my lord. But here is a decision of this honorable court if a lordship is correct.
You can ask all these questions to this witness. Which paragraph, sir?
That is, my lord. Last paragraph, my lord.
Yes.
Is 18 last paragraph.
Thus adequate power.
Thus, adequate power has been conferred upon the court to recall any witness at any stage of the proceeding. Rather, that such evidence must be essential to the just decision of the case. Obviously, there cannot be a straitjacket formula to hold us to what would be
That's precisely the trial court has done. That's precisely given the reasoning for that. Petition is agreed by the order dated 3/9/2024, whereby the application of the prosecution under section 311 CRPC was allowed, and the prosecution was allowed to summon two witnesses, namely Lakshmidhar Naik and Rashmita Raut. The learned trial court, by evaluating the circumstances to recall to summon these witnesses, have summarized the facts in summarize the facts as under page 17, page 17, peruse the record, see paragraph and 18 pura. The trial court has meticulously dealt with the facts of the present case and arrived at the conclusion that these two witnesses sought to be summoned by the prosecutions are necessary witness, those who have those who were intricately involved in the occurrence. Involved in the occurrence. I find no reason to disagree with the trial court summoning these two witnesses. Hence, the petition challenge for the petitioner, who are the accused in the present case, fails. Accordingly, the petition is dismissed. Yes.
But see, my name may be requested. I am for information. Sanjeev Kumar Das.
Informator. Yes. Next.
28.
My lord, petitioner is seeking for the postponement of the proceeding on the ground of ingredients of offence are not made out, my lord. My lord, complainant.
The case about the order of against is 2006 order. And you express submission after delay of 18
2006. What is the stage of the trial?
My lord, just commitment now. Commitment.
No. 2006. It might have been over by now.
My lord, now they are.
Where have you said that what is the stage of the trial? Where have you said in the petition? Yes. She is doing well. Why are you worried? If any problem, I'll call you. Where have you said, ma'am? What is the stage of the trial? Because the cognizance is taken 2006.
Yes, my lord, but my lord, they are employees of that.
No, not on merit. I am just asking, what is the stage?
Okay, ma'am. Okay, ma'am.
Trial might have been over by now. I don't know. Have you said anything in the entire petition? Stage of the trial.
Petition no one mentioned about the delayed part.
Why have you come so late?
My lord, I am aware about that, that the case is against me. That's why I'm not.
Yes, the case is against you, therefore you have come. But in 2006, this has happened.
My lord, that in 6/5/2024, I'll arrested before the session judge.
What is the stage of the trial, first of all? I list after you read, you get instruction. I'll list it after 2 weeks. Tell me the stage of trial. The petitioner has challenged
I know it is a commitment on 6/5 to.
You have to be sure about what you are saying.
Yes,
2006, today it is committed. It might have been committed long back. Do you have any instruction to that? What?
My lord, yes, registered on 2006, but the arrested in 2024. Issue of NBW.
Where is that?
The equal is under 8. And another moment. But it's the running platform is wish to issue
Page 20, my lord.
20 10 1 6 hours.
20?
26 10 1 6 hours. That is case 18 hours.
18, where is that? 18.
Case 18.
Yes. 26
10
2006.
NBW is
petitioners are conducted for class since 18 years. 18 in the
is the employee of finance company. The complaint lodged the complaint petition against the vehicle was theft by the present.
But from 2006 till today, why have you not executed the NBW? You don't execute the NBW, what to do? And you are in custody now.
No, religion.
Got the bail.
My lord, page.
And see, I'll tell you on 6/5/2024, they appeared. Whose fault is this?
Due to non-existence,
Then?
That's me. Last 2006 also, the whereabouts notable to arrest by the investigating officers that may be happened in this case also. Because the order was passed in 6 hours.
You didn't execute the NBW. What to do?
Then that to get the also in this case. Also,
I'll just simply expedite, okay? I'll expedite the trial.
All the point arise before the trial.
You raise all the points, tried out.
Petitions in 3
Petitioners, how many petitions are there?
3.
Petitioner has challenged the order of cognizance.
1 petition.
Dated, when in that order, no, petitioners are seeking quashing of the entire criminal prosecution initiated against them in ICC case number 168 of 2005, corresponding to ST case number 56 of 2024. On 26/10/2006, cognizance of the offences punishable under section 447/395/506/294/34 IPC was taken against the petitioners since they were absconding during the investigation. NBW was issued against him. The NBW issued by the court of STJM remain unexecuted for till 2020 till 6/5/2024. On 6/5/2024, the petitioner appeared before the court and sought for cancellation of NBW. The NBW was cancelled and the petitioner was admitted to bail. Next paragraph. The petitioner has now challenged the entire criminal prosecution initiated against him on various grounds. I'm not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage. Regarding head to the fact that the complaint is filed way back in 2005 and it is pending adjudication since about a decade, 2 decades or 2 decades. It would be expedient that the trial court should take necessary steps to conclude the trial as expeditiously as possible within a period of 6 months. Yes. Preferably within a period of 6 months. Yes.
Okay.
Yes.
29.
May I please your lordship? Lordship, in this case, the petitioner is coming to this honorable court for quashing of FIR, my lord.
Yes.
In this case, the alleged offences under section 307 along with other offences, my lord. The petitioner and the victim as well as informant both are of same village, my lord. And the FIR was lodged in the year 2018, my lord. Till now, charge sheet has not been submitted by the IO, my lord.
Yes. 2018 FIR. And sequence. 2 weeks up. And counsel for the state seeks 1 week adjournment to ascertain the stage of the investigation, lease the matter on shoot. Yes.
Notice may be issued to the opposite party.
I have issued notice, yes. Notice to opposite party. Yes.
38, 2017, warrant has been issued by law.
Warranted.
NBW.
17. You are on bail.
Yes. 16. And next copy. Page 7.
Tell me the date.
26/10/2016
bail. 30/8/2017 NBW. ठीक है. Pay 1,000. Yes. Next.
31.
Here the whole family members of the principal accused, mother and father-in-law, brother-in-law, and the wife of the accused have been implicated falsely, saying that 376(2)(n) principal accused is in the custody, is in the jail. But the FIR was lodged after 8 months. And allegation against the petitioners that they have scolded her when she came to the house after 6 months. And the old mother of the accused, principal accused, and father-in-law, they are mainly connected these offences.
34 is there.
34, but 376(2)(n) incident occurred 8 months before in the lonely place of the jungle. But the allegation that they went to the house of the brother-in-law and father-in-law.
What is the stage now?
Stage is there because against these petitioners, no charge sheet has been submitted, and accused is in custody, and that is posted for charge against the accused.
Charge sheet has not been filed against you.
And not filed. They kept it open.
Then why are you coming?
No, because SCST Act is there. So
I can't preempt if it is charge sheet is not filed. Why should you file the quashing?
So they have kept it open.
Then I can't close it now.
Because
173(8) they have a right to keep it open. It will go on.
Yes. But SCST Act was made and
they could not. Charge sheet is not filed against you.
Yes, charge sheet is not filed.
You
are accused from the FIR. SCST Act is not made out, and 376
after forget about FIR. After investigation, charge sheet has been filed. You have not been made accused.
Charge sheet against us is not filed as on date.
Then
173(8)
Can any court can close it investigation?
No, not
then.
Watching
so why are you talking so absurd? I don't know.
Watching
what cause of action you are?
I have claimed
after FIR charge sheet has been filed.
The charge sheet in respect of the present petition are not filed.
I think I can understand what you say. What petition you have today?
Because of the FIR named in the FIR.
I've been giving the FIR. Although I need to understand the name in the FIR is now nothing to do, now charge sheet has been filed. Charge sheet not been exonerated, you know,
It has not been filed in respect of us.
They have so many problems. He was used by the fact that 173(8) is open. Yes, you want that it should be closed. They should not investigate against you at all.
No, that I cannot say.
But what you are saying,
I am challenging FIR. FIR, I am challenging the FIR because
petitioner has been arraigned and accused in the FIR number PS case, Baliguda PS case number 44 of 2024. After investigation, charge sheet in the present case has been filed on 21/4/2024. In the charge sheet, the petitioner has not been arraigned as accused. However, the petitioner is apprehensive that he may be made accused. Since the further investigation under section 173(8) has been kept open. Open. Next program. Since the petitioner, since against the petitioner no charge sheet has been filed, the petitioner doesn't have any locus standi to challenge the proceeding at this stage on the apprehension that they may be made accused after the conclusion of further investigation. The petition is premature, hence the same deserves no merit, hence dismissed. Yes, next.
no, they had apprehension of arrest because of the FIR. And petitioner number one name may be
apprehension of arrest is 438. No, apprehension of arrest is not an
CSP Act is there.
I have passed the order.
A petitioner number one may be deleted because he is not there in the case. I wrongly added him a petitioner.
I have said premature for everybody. Yes. Next.
The petitioner number one may be deleted.
And then counsel for the Mr. Bahalil as counsel for the petitioner submits that petitioner number one is inadvertently arrayed as a party to the proceeding. He wants to he seeks leave of the court to draw him as a petitioner in the present case. The prayer is allowed. Yes. Yes.
May I please ask? Well, I am challenging that the order dated 28 August 24. Malab denying me the or entire document under section 207 of the CRPC.
Yes. 207.
There is 91.
90?
Yes. 91.
Yes.
The impugned order says it's voluminous and petition has been given as per 207 proviso. There has been the opportunity to verify the same.
No, that cannot be. The distance is otherwise I'll file two distance, my lord.
If it's voluminous,
Voluminous or whatever.
You have to give.
Why you choose and seize everything? What is the practice is, I'll tell you. Practice is you raid somebody's house, you take everything from here.
it's a case of a misappropriation.
I know misappropriation only. You get inside the house in the name of raiding. And you take every possible paper in the house.
No,
You don't scrutinize, then file it.
no, charge sheet has been filed and the list of documents are.
207 is right. You want.
Tarun Shak's case, my lord.
Yes.
Tarun Shak case रे से कोर्ट କହିଛନ୍ତି ଯେ ଆପଣ ଯଦି ସେଟା ଥିବ ଯଦି
जहाँ से जहाँ से
I'm not refuting that. Thing is that if it is voluminous, statute says that he can verify it. Instead,
no.
it cannot be provided.
Cannot be provided.
Can you see the proviso?
Read it.
If the magistrate is satisfied that any document referred to in clause is voluminous, he shall, instead of furnishing the accused with copy thereof, direct that he will only be allowed to inspect it either personally or through pillar in court.
You show me the judgment now.
My lord.
Yes.
Nursing Singh.
The provision.
How many pages by the way?
500 per खंड पेज हो.
अगर मुझे सीबीआई केस रे देखा दीटा मतलब बस्ता नहीं देछन.
आ बस्ता नेले बस्ता के
What is how will you define voluminous? You tell me. Define voluminous.
से तो जहाँ से
No, you explain what is voluminous.
voluminous means it is
You and everything you can't say voluminous. 500 page is not voluminous.
की बेसी हो कि
Tell me how. That is what I'm asking.
नहीं एथिल 500 नहीं जहाँ से देछन 1000 पर खंड बिल खाली 1000.
Exactly how many pages you tell me?
गोटे गोटे वॉल्यूम रे गोटा कर अछि
हजारे केते हजारे ताको डॉक्यूमेंट में कहूचे हजारे
show me which paragraph.
1000
मतलब first my washing में
61 आउ गोटे अछि एमिति 3000 खंड पेज आउ सेबरा सब कोन मागी चंती
Why are you increasing the volume so?
हजारे
You exactly tell me what is the volume. Whether it is there is a logistic problem or is the problem otherwise.
अरे जेरॉक्स ऑथराइज किसी नहीं कौन से डॉक्यूमेंट मागी चंती एठी ओनली
माजी से कोने आपको जहाँ रिले करते नहीं आपको गिव नहीं
1 minute.
एथरे मागी चंती बिल नंबर दियो
अरे माजी में कौन सेटा आप रिले करते
Unless
statutory provision can judgment supersede statutory.
no statutory judgment, it says voluminous doesn't mean that every voluminous. Unless you say me how many pages you have said 500, now you say 1000, thereafter
से छोटा देई चंती कोटा कर अछि 500
you tell me exactly what is the voluminous according to you.
वॉल्यूमिनस को एथरे
According to you, what is voluminous? Voluminous is it. You try to appreciate one thing. A person is facing he is an accused. You have to defend himself. Indefensible right. That's why you can't withhold your papers like this.
इतने
Merely saying voluminous, unless you define saying that voluminous.
गोटा कर अछि
10,000 to 15,000 pages, I can understand.
ने एठी अछि गोटा कर हजारे 161
If I'll ask you to file a written note, you are filing 1,000 pages.
नहीं
I am making you to read 1,000 pages. That's not voluminous. No, if you are asking some papers, that is voluminous. I will be able to file what is not voluminous?
से तो गोटा कर हजारे 161 पेज
You just let us don't go into the technical. Don't go into technical. You tell me how many pages. Let us find out a way.
ठीक अछि
Let us find out a way.
गोटा दूज केते पेज अछि टोटल केते पेज
Let him go again. And you also try to be reasonable. What is relevant to just the best way. What you have a larger experience. What we used to do in the practice days is we used to go flag it and ask them to give the copies. It is a voluminous document. Whatever relevant, we used to tell.
मतलब एक्सपेक्ट जेरॉक्स पेपर में नहीं जेरॉक्स मुझे दे दूँ so when जेरॉक्स चेक पे जाओ इतने volume तो it is higher to people giving
Whatever relevant you take it. Why are you carry on?
all those are relevant. That is why I'm asked for.
So you want to inspect and point out the relevant document, they will supply. I'll record that. That's better way.
that
Let him first मतलब verify.
I'll put it on. 1 minute. I'll put it on 21st. You just tell me.
मतलब 22nd मतलब
22nd. Okay. 22nd. You tell me
केते पेज
get the pages and all. What I'll do is I'll allow you to inspect and flag it, and the relevant document which will flag you will supply. Simple.
recently मतलब in a CBI case they have the same ground they had taken. Well, I had cited this judgment, but CBI court allowed and they gave me 2 bundles of paper.
Mr. Pal, these are not such a legal issue to be argued for.
Yes, it's not that.
Find out the way and I'll tell you. I'll do it. I'll do it. Yes. You are interested in your paper? Yes, that's all.
That's all, my lord.
Why are you arguing like a constitutional issue, giving judgments and all?
So because it is my right, my lord,
You will get me copies.
सबले दिया हो
He will give you.
my lord, I don't 36 man.
Yes.
So fresh admission.
Yes, admission, 2 years service.
Yes, appeal admitted, bill granted, realization of the state.
Realization of fine also.
Yes. TRO called for. Yes. Free copy given. Free copy given when Mr. Sanjay Das name. That you forgot to tell.
Your lordship has already informed.
Item 41 is a Belgium matter, madam.
Belgium 41.
Milo.
41. However, we are here. We are 37. 32. Belgium is Belgium.
Item 39.
Belgium could
Item 39 40 Belgium matter.
Belgium could have छोटा yes
39 40
39 yes I'll take it up small matter Belgium I'll do it rest of the matter after lunch yes 39 bail yes
6th April 22 and
use mic Mr. Vishal yes use mic yes
6th
My
April
lord, item 39.
bail granted. And NBW issued 24 January 2024.
Tell loudly so that we can hear it.
The bail was granted on 6th April 2022. And the NBW issued on 20 January 2024. More than 40.
My lord, item 40. My lord, Belgium matter. My lord, answer 1, page 9, in blue order, 13/2024.
On 10th March 2020, to 2006, and NBW was issued 13 September 2022.
500. Yes.
41. My lord, item 39, Belgium matter. In blue order, 24/2024, my lord.
Yes, 41 my lord. The petition was released on bail on 24/2/2012.
And
At test 10, my lord. NBW is 6/2023. 23. Okay. 500. Yes.
My lord, item 39, Belgium matter. In blue order, 24/2024, my lord.
42. You tell me.
Lordship, NBW has been issued on dated.
Yes. Why don't you write it in the top of the brief? You have to give.
Item 39.
For that you take 20 minutes. 12/12/2022 NBW. ठीक है, डील कर दो 500. Yes.
My lord, I beg pardon, my lord.
What do you want?
Can it be because, but tomorrow onwards it will become infructuous, the criminal revision, because 18, 19, the trial is there before the CBI court at Bhubaneswar. So if your lordship kindly put it physically at 2 p.m. tomorrow, we'll be there and we'll finish it up. 15, 20 minutes matter. It's not very lengthy matter at all.
20 minutes is not short time. Anyway, I'll take it up tomorrow.
Tomorrow at 2 o'clock, my lord.
No, I can't give you time because giving time is very difficult. I'll take it tomorrow. And wait till 3:30, let us see. If I can reach, I can hear you.
Yes, 3:30, today 3:30. Yes, madam. I'm
If
ready.
I can reach at all. Yes.
We'll be ready. We are ready, madam.
3.
I can say, my lord, non-responding in this case. So your lordship will pass.
No, sorry, I didn't follow you. What is?
This is the case, my lord, 10 persons are cheated by this petition by not providing the certificates for which they filed. Thereafter, they were saying that their matter has been settled. And your lordship twice directed to the informant should appear in.
Yes, informant.
My lord.
If informant will not appear, how you?
And 420 is your lordship's the affair is
At least
the
one time.
420 they can also my lord compound their mind.
I'll give that option. You go only 420 convenience is taken. It is compoundable. You can very well do it. Right up. Petitioner,
320.
petitioner is taking Quashing of the Burgard Rural PS case number 93 of 2023, registered for alleged offence under section 420 IPC, which is pending in the court of SDGM Burgard. The petitioner contended in this petition that he has settled the dispute with the informant and other affected persons. Notice was issued to the informant on 28th. On 28/8/2024, the following order was passed. Following order passed. 28/8/2024. Again, the matter was listed on 24/9/2024, and on request, matter was adjourned. Today, when the matter was taken up, none appeared for the informant. However, the petitioner is present in person. But in the absence of the informant and other affected party, the FIR cannot be quashed on the ground of settlements. Therefore, I am not inclined to give indulgence to the petitioner in the present petition. However, liberty is granted to the petitioner to move appropriate application under section 320 of CRPC, seeking compounding of offence before the court below. If such application is moved, the same shall be dealt with in accordance with law. Yes. For 320 application you move. Yes.
21.
Yes. Yes.
Your petitioner is the coordinate and opposite pattern number 3 is the wife. After lodged by the opposite pattern number 2, father of the opposite pattern number 3, and substantial of 363, 366 IPC. Now they are after marriage living husband and wife.
Where have you said that?
Ground yellow tea.
They are living in high wife and husband. Okay. Issue notice to opposite party number 2 and 3. Written within so and so. In response, the petitioner submits that the dispute has already been settled between the parties, and opposite party number 3 has already made it with the petitioner, and they are happily leading their conjugal life. Issue notice to opposite party written and so and so day. In the meantime, proceeding before so and so state. Yes.
33.
Matrimonial dispute were married.
But first has been filed or not, that effect.
You get instruction.
Your yellow tea.
A charge sheet has not been filed. Only this. So what proceeding there? There is no proceeding.
Your yellow tea. Another I not to take any positive action against the petitioner.
Stay wala kar de. It is only issue notice. Investigation is still going on in this case.
That but not to take any positive. I have because he anticipated
Rejected, that's the problem. I can't, in view of the aforementioned statement, since the investigation is still going on, no court's action shall be taken against them. Because they are already married. If it will be taken into custody, their marriage will be affected. Somehow they will settle, unless it is going to create their marital problem in the life.
One more thing, 6 postcode is concerned lots of 7th of this month, Hon'Ble affects for a deliberate judgment. Lots of before launch, lots of that judgment, you have gone through that judgment.
While Quashing you show me. As a POXO is that, then anticipated will reject.
no yellow this is there.
Because
POXO is there.
that is the
POXO is not there.
minor, because at the time of the occurrence, the
No, you have not filed charge sheet. FIR, there is no POXO. FIR, there is no POXO.
you have
21, no? Item 21.
yes, your option. That is month of December, October 2023.
But see, in the FIR, no POXO is there. But initially, you have not filed charge sheet so
Yes,
far.
sir.
So how do you know? Let us presume that there is no POXO.
At the time of
Let us presume so far. And they are married. Okay.
33.
Yes.
33, my lord.
Yes.
The petitioner is the chief servitor of Jagannath Mahaprabhu. My lord, a case has been filed against him, which is at running page 16. He prays for quashment of the entire proceedings against him. If your lordships kindly turns to page 16.
16. Yes.
16.
Yes.
My lord, the FIR which has been lodged is in inviting the subject cited above. I am directed to state that before Pondi of deities to Sri Gundicha temple on day following Sri Gundicha Yatra on 28/2015, a Sevayat of Pratihari Nijog, namely Sri Kalijuga Atatrana Pratihari, had taken a woman pilgrim unauthorized to the chariot of Sri Jagannath Ji by violating the orders of the Honorable High Court dated 26/2014, and also an order of temple office. The Bodograhi Daitapati of Sri Jagannath Swami Mahapatra, the present petitioner, was also present on the chariot, who came forward to the front side of the chariot from behind to welcome the Sevayar, Sri Pratihari, for doing such violative deed. The fact was crystal clear through video clip reveals that though the JTP in charge of chariot, Sri Samartha, was refusing the Sevayar and followed them up to the DT for bringing them back from the chariot, the Sevayar and the unauthorized lady did not listen to him. The report of Sri BB Sahu ASP made responsible
Yes.
to JTP as he did not.
What is the offense? No offense.
Yes.
You violated some High Court direction, do whatever you want to do.
Yes.
And also, before proceeding against him, they need a sanction of the chief administrator. That is also not there.
What is this unnecessary? Somebody, all sometimes do like that. And you also might have done sometimes. Every time this happens. They pay little money, they allow you to go do this.
And nowadays,
He has, everybody has an anxiety to have darshan, a better darshan. Everybody employ different methods.
Every day there will be a case.
So then I'll quote straight away. Why to waste time unnecessary? I'll quote it. Side of petitioner is agreed by the any other thing you want to tell?
no, not. I gone through.
There is nothing. There is no offense at all. No offense is made out.
The other technical points are there, which my learned senior has raised in the writ application regarding limitation of.
Why to go into it? You will also be free. Right on. Petitioner is in this petition is taking Quashing for the what is this order then? 21 order? Cognizance. Acha. Quashing. What is the charge sheet? What charge sheet says? You read the FIR. Charge sheet, anything is made out? What are the offences then?
188 IPC and 30 of the Temple
Temple Administration Act and 188 of the IPC. Your Lordship, nothing is made out.
It says
188 of the IPC.
188.
Yes, sir.
Yes, read it out.
Violation of the public.
Disobedience to an order lawfully promulgated by a public servant, if such disobedience causes obstruction, annoyance, or injury to persons lawfully
Okay,
employed.
and petitioner is agreed by order dated 21/8/2017. 21/8/2017 passed by STJM Puri in GR case number 1867 of 2015, whereby cognizance of offences punishable under section 188/34 IPC read with section 30 capital A bracket 4 bracket small b of Sri Jagannath Temple Act has been taken against the petitioner. The allegation against the petitioner, where have you written the allegation of the petitioner in the present case? The prosecution alleged against the petitioner is as under para 2 of the petitioner. I perused the charge sheet and the document form part of the charge sheet, and I'm satisfied that no case under any of the provisions of law is made out against the petitioner. Rather, the allegation allegation against the petitioner is violation of the direction of the Honorable Supreme Court dated 28/6/2014 passed High Court, passed in any need petition, anything?
No, Malak, that simply said order dated 26.
Passed by the Honorable Supreme Court in some proceeding whereby restrictions are being imposed for during Rath Yatra this happened. Restrictions are imposed for the visitors to enter into the chariots. in my considered opinion, no case is made out from the material placed before the court in the charge sheet, hence the order for taking cognizance by the impugn order is not sustainable under law. Accordingly, the same is set aside. Yes.
That is order dated
And
in a WPC
moreover, subjecting to the petitioner for the rigors of trial on the basis of materials which form part of the charge sheet would be futile exercise. Therefore, under the principle laid in by the Supreme Court in Gyan Singh and so on, the petitioner need not be subjected to the rigors of the trial. Hence, the petition deserves merit. Accordingly, it is cost. Yes.
And a WPC number has been mentioned in the, that is 10475 of 2014.
See order लिखिए ना. The order dated
WPC PIL number 10475 of 2014.
ठीक है. Okay. Yes. 34. Yes. Yes, 34.
Let's me kindly see annex to page number 916.
Yes.
Now, in this case, the learned STJM of the acknowledge who has passed an order citing the judgment of Apex Court and this court's judgment to release the vehicle illegally carrying food charcoal. Despite having this order, the opposite parties deliberately defying to comply this order. Without availing further remedies available to them, they still remain silent, defying
The order is not executed.
not executed.
Yes. Have you filed review against this?
No. I have to take instruction.
Yes. Then also for the petitioner submits that despite the order dated 11/9/2024 passed by learned STJM, allowing the application of the petitioner under section 503 of BNSS by directing to release the Velour pickup vans, the pickup van involved in the PS case number. Where is that involving?
Involved in
Which case?
transporting the
Which number?
number
OFA.
page 16. Register number would be 15.
Case number I'm asking.
So,
This case number 121/2024. So this is case number 8/2024.
Yeah, OBC case 8 of 2024. 24. Mr. Vishal accept issue notice. Mr. Vishal waives notice on the date and seeks an adjournment to get instruction regarding the implementation of the impugn order. Okay. Or as to whether any revision is filed against the said order or not. Yes. Next.
and also the LRC may direct the extra copy, all of the
Give extra copy. Yes. Next. 35. Yes.
well, this matter is settled between the parties. May I draw your attention to the affidavit filed by the informant.
Yes.
I am appearing for the information.
My lord,
Correct. Yes.
the affidavit, Parag, it is humbly submitted that I am the wife of the injured. After lodging the case, I realized that the present petitioner no way connected this case, and he had been dragged into this case by some rival persons who can also motive and a malignant intention. Therefore, on the interference of our privilegers, when we search the matter has already been through, and I kindly turn to the implement lodged. Page
Yes.
Page 11, my lord. She named the accused person, the lordship from the 11 line from the bottom. Swaraj Das ମୋ ସ୍ୱାମୀର ମୁଣ୍ଡ ଦୁଇକୁ ଦୁଇ ଚୋଟ ପକେଇଲା ମାନେ he was carrying the kati and she ଦୁଇ ଚୋଟ ପକେଇଲା. He shot her. Yes. And now she is saying in the that she is no connected.
Yes, my lord. Kindly have a glance in the injury report.
Show me the injury report.
Absolutely, there is no assault.
Injury report. What he says is what kind of affidavit you have filed. Affidavit you must file.
Yes, my lord.
Whatever you say, and factual affidavit has been filed. But the fact remains that the affidavit, the affair was written by someone, and she has given his signature. That is. When where injury report they have mentioned in police mentioned that so many injuries in head, fracture, and the medical report which not injured. Injury is the
First page, kindly see first page. First page, calling the lecture clear हो गया.
कौन lecture? Why don't you clear? Why that in the one has the right to argue?
I'm just assisting. No,
Can't stop him to argue. No, address me whatever you want to say.
second best section, first page clear.
One minute. Informant is there. Now tell me here in the post title. Who is informant?
Runnuwala Naik.
And who is injured? His husband or husband. Where is he? Who is not there?
My lord, in the 2009 he passed away by jaundice.
Whether the death is because of this injury?
No, jaundice.
Case is 2008. Your injury report. This is
That is there, man.
the injury report is not legible. And fracture of both legs are mentioned. The ASI requisition to the surgeon of the superintendent MKCG mentioning that the person sustained injury on each person on so and so date night about it due to assaulted by Aurobindo Behera. Where does it say that is simple or grievous? That is not legible. It is incomplete report.
That is there. That is the report.
No, you verified. Yes, yes. Whether it is grievous because it appears that severely damaged. Yes, yes. Both the legs were severely damaged. Yes.
And no assault on his head.
Let us see. Yes. Verify the. I had supplied at the time of mention. I had supplied. He has to verify the injury. Next. When it will be taken up? Yes.
37.
After a week or so. Yes. 1 week or so. After 1 week, huh? Yes, 1 week.
Present,
Let them present go. 307, why are you leaving them then? Let them come. No, I am not saying that date be given so that they will give a date. After 1 week, he'll give it. Yes. Verify the injury. Yes, yes. If injury is not very serious, the injured has already died. Serious injury, but I will see, you get instruction from the IO of the case. Yes, yes. You just tell me whether he died yes.
37.
A date be given so that 37 years. Okay, sir.
Here, my lord. Still, the learned senior Mr. Mishra is supposed to argue. He is on this like I am starting this matter here. Yes. The petitioner challenges the order dated to 2/8/2024, my lord, wherein my lord, my discharge application has been rejected, my lord. This is under 13(2) of the PC Act, my lord.
Yes.
Earlier, my lord, the petitioner has approached before this court in CRLMC, my lord.
Yes.
There has been, well, lordship has given liberty to file this application before the trial court, and accordingly, this application has been filed, my lord. The case is like this, my lord. The prosecution allegation is that
In the year May 2012, my lord, the present petitioner who was working as an auditor, local fund audit, Dhenkanal, and he went to Kanina block during May 2012 and collected huge amounts of money from different officers to rectify their defects, my lord. That is the allegation, my lord. And then on 7/7/2012, my lord, while the petitioner was coming to the office, district audit office, my lord, the business authorities came and found 1,14,800 from the possession of the petitioner. That is the case, my lord. And accordingly, FIR has been lodged in 13(2), that will be 13(1)(d) E Act, one of the PC Act, my lord, and charge sheet also submitted in the year.
Yes.
In the year 2023. The case has been registered in the 2012, my lord, and after 11 years, they submitted charge sheet in the 2023, my lord. Now, my lord, the grounds I have taken for discharge of this dischargeable petitioner, my lord. My first ground is that, my lord, the prosecution allegation is that the present petitioner has collected huge amount of money during audit done in the year 2012. That is the difference, my lord. And in the charge sheet, my lord, none of the persons or officers have been showed as witnesses, charge sheet witnesses, to show that the present petitioner has collected money from them, my lord.
Yes.
Second ground, my lord, it is the case of the prosecution is that one Akshay Kumar Mudali, auditor, and Fogu Bhaira is, my lord, who also accompanied the present petitioner in that audit report, my lord.
Yes.
They are also not shown as charge sheet witness, my lord.
Yes.
Thereafter, my lord, this is a case of disproportionate of asset, my lord. And my lord, in this case, there is no check cleared, my lord. No check it has been shown, and it has been shown that how much or what extent of money is disproportionate to his income, that has not been shown, my lord.
Yes. Yes, but who is appearing? Vigilance?
Yes, sir.
Have you seen it?
My lords, there are materials, my lords, which disclose great suspicion with regard to this complexity, my lords. Admittedly, I mean, for my learned friend of Price lordship, that
1,14,800.
after this, my lords. I mean, in fact, we got the internal reports that this gentleman, the petitioner, lords, when working as an auditor in the Dhenkanal region, lords, lord, he used to collect huge amount of money from different officers in a bid to regularize the defects pointed out during the audits, lords. Lord, that's a opportunity encashing in illegally, lords, and we used to collect money, lords. And now, after getting that interception report, a team was from lords. And it was when we come out from the office notes, it was intercepted, and amount of 1,14,800 was recovered. This is in a carry back notes. This is admitted notes. These materials of petition notes to go with secure material to purchase notes.
Let me clarify this statement.
So what I suggest, Lord, when you are no satisfactory, no possible explanation for coming notes, in fact, they fail to give any kind of accounts with respect to reports. And the regions, Lord, they have also put for the different claim lots that 20,000 I got from my son, 1 lakh rupees from my wife. All these things are different place lots.
What is the DA?
The due amount what my lords was indicating on that particular date, my lords, that 1,14,800 on 7/7/2002. So on that particular date,
He has two grounds. One ground is if you are saying that he has been collecting huge money and you have not cited any of them as a witness. And second is there is no check period, there is no DA coming forth from the except 1,14,000.
yes, my lord friends is expecting that particular the day, the check periods and how this. But here, the date of the seizure notes is the check period, that is 7/7/2010. And the amount is 1,14,800, which was not connected notes. Promise possession.
You have to explain that.
You have to explain that, and for that reason, he says that so and so witness why they were left out, when so they are not left out.
He is admitting that they have a weak case against him. But they have case.
That's kind of still and Lord, these are the submission, Lord. I agree, Lord. These are good defense claim, Lord. But it has to be established, Lord. Where? By additional evidence in the trial courts.
Yes, what do you say?
My lord.
Now, when you have a case for discharge, you may be acquitted. No, you will definitely be acquitted.
Evidence to that effect.
My lord, kind of Lord.
Yes.
By which my discharge has been discharged.
I read it.
My lord. Here, my lord, I have also given the defense I have taken. I have also given the bank statement, my lord. That, my lord.
At this stage, I don't think I can go into a due aspect.
My lord, but the court below, my lord, that has not taken consideration. And my lord, kindly come to page
It's very detailed,
19, my lord.
very detailed order.
And reason of
Yes,
Very detailed order.
those things they have not discussed. The trial court has not discussed the defense plea, my lord. Only, my lord, simply say,
Defense plea cannot be, gone through this thing.
no witness is there. And my lord, the present petition, wow, when he was restrained, he is admitting, he is coming to the office, my lord, not he is coming out of the office.
He is very hopeless.
Why he is coming to the office, my lord?
all these belongs
On the, my lord, on the road, my lord, he is coming from home. It is not a case that he has collected money or somebody has came to the office.
The government officer will explain that the amount.
They have not taken. I have explained everything, my lord. They admit my explanation, my lord. How they can proceed with the case, my lord.
I can do one thing that I can expedite the trial.
yes, and then also give them the and also to recall this.
May I assist your lordship, my lord? My first submission.
He is so effectively argued.
No, that is more effective than me, my lord.
Yes.
But my first submission for lordship would be that affair was lodged in 2012. Sanction was taken in.
That is the reason I am expediting.
Then what I'm trying to
The matters, that's all.
as would be materials available in record, there is no evidence on the part of the prosecution to prove that somebody possessed 1,14,000 on a particular time or particular date. And secondly, first submission we made suspicion.
Stop. No, I said
Surmise cannot be ground to for trial. I've been retired. Allow me to complete. I've been retired since long. Again, I have to lodge that court and to face trial.
Therefore, section 20 is there for you. Section 20 presumption is there. Rebuttable presumption, you can lead evidence. What I could see from this entire thing. It's a case of 2012. I know, I understand it is a trauma.
It means two things, my lord. One, there must be demand.
no, that's
He's trying to do that. I have now I have another 2 lakhs with me. Can you be constituted?
You should be happy that they have not gone into your house and making
They are not single property of mine that is there, my lord. I have not watched a single property of mine, either vehicle, nor the property.
you must be there on bail within 6 months. The trial has to be completed.
yes.
And nothing should be there and then. Nothing you don't have anything to.
That's liberty is good enough, bro. They should be happy for that.
Nothing is there. And at the age of 70, again I have to go and take.
So many appeals.
And Article 21, I think is well aware that 2012, the allegations are not so made or it is not 5 crores, 10 crores, this type of percent money.
Yes.
That they have taken 11 years to take the sanction, and so I can also take note of, to submit before watching, so I will also take note of Article 20.
So the is concerned.
That's the reason I'm expediting within 6 months, they have to complete. Somewhat. Yes. 2012 matter, no evidence is there.
No, so fixed, stipulated.
It is regulated by the order detail. I agree that I will give some judgment before lordship. I will give some judgments. These are the. Okay, judgment trigger, you give in writing. Yes, I will give the judgment. You give it, I'll take note of that. Yes. Judgment trigger will be, huh? Yes.
38.
Okay. Thirty-eight. Therapy?
Yes, ma'am.
Yes.
Yes, that authorization.
Make legal lordship.
To take instructions. But whatever document, it all has been relied upon, nothing has been taken.
Your Lordship, as per the direction of this court, we are filing the order sheet dated 9/9/24 to 6/11/24. The order 5/11/24, the order still stands that the is yet to file a compliance report. No, just file the order sheet.
No, have you seen it?
No, not.
He says that all the documents are reliable.
All has been relied upon on those who are served on that.
But Governor, that has not been filed yet in the court.
Because of 9/9 PO was on leave below. So that memo is ready. On the next date, we will file that memo.
Had it been a compliance report that it was filed before the court, then court taking up the discharge petition, we have no objection to that.
Discharge petition, your also kindly see page 140,
1?
150, 150 below.
Yes.
Last time. Last time. And
Yes.
reliance upon documents have already been received by the accused petitioner.
151.
150 last time, 150 below.
Yes, one, yes.
Last time, that is, and the relied upon documents have already been received by the accused petitioner.
Your Lordship, we are just asking for the undelivered upon document, not the
That's what he said, I'll record that.
I have given my instruction, I have received.
Your Lordship, had it been like an affidavit.
Petition is agreed by the order dated 16/8/2024, whereby the application under section 227 CRPC for discharge has been rejected. A petitioner in the present petitioner has raised three issues. Returning the first issue.
The first point is that there is no scheduled offence existing against the present petition, because that has been drastically.
Is that in the absence of any scheduled offence existing against the petitioner, PMLA case should not have been fastened upon him. Second is that 44(1)(c) mandates that the records from the scheduled offence should be transferred to the procedural code. Section
44(1)(c).
44(1)(c) mandates that the records pertaining to the predicament offences should be transmitted to the PMLA code. Third one is that on 7/8/2024, the petitioner moved an application under section 207 CRPC for supplying the unrelied documents. On that day, the trial court directed the prosecution to supply all the unrelied submitted before the unrelied documents. However, and urgent matter for 9/9/2024. However, without the supply of those documents, the trial court on 16/8/2024 proceeded to frame charge, proceeded to reject the application under section 227 CRPC moved by the petitioner for seeking discharge. Then counsel for the petitioner submits that the trial court ought to have waited till all the documents are supplied to him before proceeding with his application under section 227. Notice was issued to the opposite party respondent, Mr. Agarwal. Mr. Agarwal appeared on advance notice and sought instruction and placed before this court inter alia stating that all the documents which are relied upon by the prosecution has already been supplied to the petitioner, which is also reflecting in the order dated 7/8/2024. Mr. Agarwal categorically submits on instruction that the prosecution doesn't have any unrelied document which is form part of the charge sheet, the charge sheet. Insofar as the first issue raised by the petitioner is concerned, there is no merit. There is no merit because the predicament offense against co-accused is still continuing. Charge sheet has already been filed. Charge sheet has been already filed. And insofar as second issue is concerned,
Which is Vijay Madhavan said, it is not mandatory.
insofar as the second issue is concerned,
Now that's
under the principle laid down
in Vijay Madhavan.
and the principle laid down by the Supreme Court in the Vijay Madanlal versus Home Society, so this is not a mandatory requirement for calling for the record of the predicating offences before the
This is not necessary. If the prosecution pays, they can file application.
before the PMLA case. It is the prerogative of prosecution to move application in the case-to-case basis. In the instant case, the prosecution has not moved any such application, as that stage has not yet arrived. If necessary, the prosecution is at liberty to move such application. In view of the specific instruction obtained by Mr. Agarwal and placed before this court in the present petition, I am not inclined to entertain this petition. Hence the same is accordingly dismissed. The keep it form part of the record. Form part of the record. Instruction is form part of the record.
Yes. My lord, just one request. My lord, in the order sheet, it is still saying that you have not yet complied with the report. In this record.
I pass your next set tape, Yes. Next.
43.
बेल कितना बेल लगता रहता है
43. My lord, I have been arrested on the basis of the statement made by the court. My lord, a similar matter, similar matter has been kept to tomorrow. That is 8463 of 2020.
Similar means call कल कर दे. Yes.
8463 of 2020.
Next. And get the CD for tomorrow also. Yes. 44.
Obliged.
44.
Yes, sir.
In this case, though I filed a regular bail application, I am not pressing for it. My prayer is for interim bail.
Interim bail.
My main prayer is for interim bail. He is suffering very viciously from diabetes. Let them take a report and give it.
Get a report. That application.
The IE is not.
IE?
No, there is no IE. The main prayer is interim. Yes, sir.
That's interim bail. Petitioner is seeking interim bail in Remuna PS case number 11 in connection with Remuna PS case number 11 of 2024 corresponding to city case number 63 of 2024 on the ground, on the health ground.
Yes.
On the health ground, issue notice to the state, Mr. Tej Pratap accept notice and seeks 1 week time to verify the health condition of the petitioner and submit a report. Lease the matter. Yes.
45 by next week, any date?
Huh?
Any date?
Date after 1 week. Yes. May Padma, my lord, item 42 a Belgium matter. 42 already allowed. Yes.
45.
No, 45. In the sub item, I am appearing 1851 2024, my lord. Last occasion, you also directed to file affidavit in regard to antecedent, my lord. And so far the my bail application is concerned, he has no criminal antecedent, my lord, and is a local person, my lord, and
Hari Gulari.
my lord, he is a local person, my lord.
Yes.
He is inside custody since 19/5/2023, my lord. 19/5/2023, my lord.
Okay.
And my lord, here, my lord,
Yes. What is recovery?
recovery is 154 kg 900 grams of ganja, my lord.
154 kilo for 400.
My lord.
Yes. He was there in the spot recovery.
He
On the expedition.
yes, my lord, he along with the other three others over there, my lord. And the present person is a local person, others are, my lord, they are outside of, my lord.
They belong to
And
Maharashtra.
Maharashtra, my lord. And so now, my lord, the chassis submitted.
What is the stage?
Stage, my lord, my lord. Last time you also call for the status report. That is there, my lord.
Where is that?
My lord,
Report.
report also.
Where is the report?
Wait for
The second one.
Where is the report? Let us see.
in this matter, my lord, the two person are from Maharashtra.
The report. 2 persons from Maharashtra and one
Is from Odisha. You also previously directed to file the affidavit. File the affidavit.
So it is to submit that on
I've stated everything, my lord. Affidavit of petitioners. No, all the petitioners. Swapnil Sande, Abhijit Vaidya, and that's it.
Abhijit Vaidya has no criminal.
All the petitioners have no criminal incident, my lord.
Doesn't accept the criminal case.
They have filed affidavit regards to that effect. But I have got this criminal antecedent regarding Hari Chandra Golan.
Harichandran?
Hari Chandra Golan. The BNPL of second item.
Yes.
1851 of 20.
How many cases?
Lordship, he has no criminal antecedent.
But what about the other two?
The other two, it has not been instructed, Your Lordship. Only regarding this.
But see, in the first matter, that is, there is a report. Have you seen the report? A report submitted by
The learned,
additional assistant judge.
that is flag.
He says that there is no antecedent.
Lordship, that is not.
Status report already,
It only says that Abhijit Vaidya has no criminal antecedent.
my lord.
Lordship.
But they filed the affidavit now.
Yes, they have filed affidavits.
What is the stage trial?
Look, I don't have.
The charge has been framed, my lord. What happened in this matter, my lord?
Charge has been framed August.
Yes, your lord.
Thereafter what happened?
Thereafter, someone issued notice, no charge scheduled witness examined, your lord.
Primary witnesses, tell me. Because August and now we are
So I will
in.
take instruction regarding the stage of the trial, Your Lordship.
And you tell me who are the prime witnesses?
Whether they have been examined.
You get it and list it on.
No, 38 kilogram, 600 gram each.
Each
Total person are there, your lord.
1,000 kilo also you divide it.
My lord,
Another thing is there.
Total is 100.
your lordship, very well known, my lord. The charge sheet submitted on 15 November 2023. No paid for 173 clause 8. Thereafter, my lord, in 7 June 2024, they filed the C report. Under which provision?
Conscious possession is there. That is the whole difficulty.
They debarred us from default.
That is the only difficult. Otherwise, that is what I'm asking. If you would have fled away from the place or something of that sort, I could have find out some way to give you. That's the whole difficulty. Get the because you can't keep them for eternity. You have to at least try to proceed.
The date.
Fix a date. Huh? 27th, okay. 27th. Fix a date and make sure that all the primary witnesses should be examined meanwhile.
May I pray one thing, Your Lordship? Your Lordship may kindly call for the depositions, if any, recorded.
Acha. Fresh report regarding the status of the case may be called from the trial court. If the witnesses have already been examined, the deposition copy of deposition may also be asked to be transmitted to this court. Okay. Great. We'll see if the witnesses are examined. Nobody has supported the prosecution. We'll let it. Yes. Yes.
46.
May I please your worship? Here, my lord, the petitioner is in custody since 15/9/2023, my lord. Alleged offence under section 302/34 of IPC.
Lordship, may I pray for last occasion? Your Lordship had asked for CD, but it has we could not.
Your Lordship, kindly my grant to the order sheet, my lord. Thrice they have taken the. I have filed since 19/2/2024. I have filed this right application. Now there is a change. Your Lordship, I am filing since 19/2/2024, my lord. Now in the month of November, my lord. Thrice they have taken time for CD, my lord. Your Lordship, let us give last and final. Your Lordship, I have the entire charge sheet, my lord. If my learned friend will give the copy, then at least, my lord. You have the charge sheet. I don't have anything except FIR. You have not filed anything. And another thing, my lord. The problem is you people have decided that when bail application is to be used, only FIR to be enclosed, nothing else. It would be visible. They argue so much. Since, my lord, these are not visible copy, if I will file, my lord, bail number will be copy to him at least. Perhaps, my lord, in this case, my lord, your lordship was directed to list this matter along with BLAPL number 2508 of 2024. That bail application has been in the meantime disposed of. That is disposed of on 9/10/2024. Granted, bail granted. Interim bail granted.
Interim bail granted.
Or CD may be available in that record. Check it up. Check it up. By way of last and final opportunity, one state council is granted 1 week time to get the CD. And land council or the petitioner submits that the matter was tagged with BLAPL number 2508 of 2020, which has already been disposed of. The CD of the case might be available in that file. In that file, the Page of Pratap would be verifying the same. Yes. You will see next week any date you also giving a date. Yes. One week. Yes, yes. Next.
84 you lost fixed.
Wait, 3 o'clock, just see it. You have to wait. Let us see. Yes.
57.
I have to exhaust the miscellaneous matter at least. Yes. Yes.
May I please, Your Lordship?
Yes.
Your Lordship, the petitioner is a woman, Your Lordship, custody since 22/2/2024.
Yeah.
Lordship, she is in custody since 22nd February
Wait. Service. If we affected service on opposite party number 2.
No, Your Lordship directed to implead only the opposite party number 2, the IO to communicate to the.
Have you implemented?
Yes, Your Lordship, kindly, Your Lordship's order dated 30/10/2024.
Order dated 30/10/2024 has not yet been complied with. As the IO has not taken a step to serve opposite party number 2, one more opportunity is granted to the IO to serve opposite party number 2. Please the matter. Yes, please.
Your Lordship, please fix this order date, Your Lordship. It's an old woman, Your Lordship.
Yes,
It's simple
next.
injury.
Yes. Thank you, Your Lordship. Yes.
May I please, Your Lordship?
Yes.
Petition case under section 395 of RBC, within section 25 and 27, I am sad. Co-appeal division bill.
Lordship, the criminal antecedent of this petition is 16 cases pending.
Has he filed affidavit? You file affidavit. Mr. Counsel for the petitioner is directed to file affidavit. Petitioner is directed to file affidavit detailing out the particulars of the cases he is involved. Release the matter. Yes. Next.
49. 49 Lordship, item number 49, I humbly pray that let this matter be taken up on Tuesday. I have already, today only I have received telephonic information regarding it. Due to some problem, it could not be done. Lordship, Tuesday it could be.
21st. Yes.
No problem.
21st.
21st of submission.
21st. But our
20.
let it come on 26th then. 26th. 26th. Yes.
50.
Yes. Yes, sir. Yes.
Manner the RSA 175 of 9/14 was dismissed due to default.
Where is that order? Default order.
Certified copy I will not.
Dismissed
default on 26/16. The cause of delay of different purchase has been mentioned in this petition, my lord. When considering this,
sir, this petition you will not file any annexure, any application, nothing is there.
I will not certified copy.
This, the
1 week time may allow, my lord.
petition is
1 week time may allow.
no, present petition is not filed.
My lord, 1 week time may allow.
Bereft of any detail, the present petition is has been filed. Therefore, the liberty is granted to the petitioner to file a fresh petition with the particulars and relevant documents. Dismissed. The petition is disposed of with liberty as granted. Yes.
But date may fix on.
No, I've disposed of file a fresh petition. There is nothing in the petition.
Only to file the certified copy of the dismissal.
There is nothing. Just see only petition without annexure, without particular, without the order. To what extent one can accommodate? File a fresh one.
I have already been made in
Yes,
in that chat.
File immediately. I'll take it up. Yes.
51.
This is also like that. What kind of petitions are being filed? I just don't understand. How is it numbered? Just one page petition without annexure, without anything. Madam, the petition is bereft of any particulars without annexure. Hence, the same is disposed of with liberty to the petitioner to file a better petition with the particulars and necessary annexures. Yes. Next.
52.
It's one, 52. Yes.
May I please, Lordship? Lord, the present CRLM has filed for restoration of the criminal revision number 17 of 2020.
Same story here also.
And the order.
Why did you file the petition? You should have sent a check to my chamber. I would have retro. What kind of petitions are this? How is this number? I don't understand. One page petition, half of the page is address and cost ID. This much is written, prayer this much. No annexure, nothing. Madam, the petition is bereft of any particulars, details, and without any annexure. Therefore, the same is disposed of with the liberty to the petitioner to file a better petition with all particulars. You file a better one immediately. And develop a practice of filing an exhaustive petition with all necessary annexure.
Appearance for the matter.
It's all right, I'll restore it. I'm saying I'll restore it. But file at least a respectable petition, High Court level petition. Yes.
51 liberty may be given.
I have given liberty. I have given liberty. Just change that petition only with one annexure filing.
May I please for your lordship, 53. My lord,
I think I will pass the same order. You find a better one. That's all.
I have already filed, my lord, going back 60, 89 pages.
Which one?
53 orders,
53.
my lord. Challenging the order of taking cognizance, my lord.
Okay.
For three,
I saw 52.
no.
God further scared. That is
79 and 411.
Yes.
Millard, 4 millard against the one subcontractor of the company, millard. And there is also a agreement is there. And the agreement is serial number 21 settlement of dispute between the parties shall be in arbitration. Millard, while the subcontractor completed his work, he is loading his materials with a vehicle, millard, OD02H, millard. 879, the said vehicle was detained and the construction materials has been seizure and left Jima of the informant. That will not in
My lord, this is case for your lordship. My humble submission for the cognizance against the offense, not against the offender. And here you also think I will say that 26, case 20.
I see 379 only. And see this informant, just see who is informant. LNT.
But CJ but proper time to return it. The informant return.
Let us issue notice, let us see. If they come, it may be settled. Issue
Yes,
notice. Issue notice. Take out notice.
Yes,
and see. Don't go into merits. Merits, then it will be dismissed. Better you.
Sir, your lordship 87 page.
Today will take.
No, your lordship no not stay.
नहीं first defend कर पके जाओ.
चलतला से टिकी है ना.
So don't go into merits. You may not succeed. Better take out notice, we'll see.
The 87 your lordship has a grants only a moment, my lord. All dispute in the opinion of the account. Arbitration. Therefore, so that, my lord.
Is that is the reason I'm issuing notice?
Yes, my lord.
Yes.
Next, the proceeding your lordship in the meantime.
You move application, application.
Yes.
Application. Yes. Next.
Notice level should go to
Sorry?
I don't better.
Entry order must be there. Entry order is there.
No, madam.
Okay. Accept notice. Yes. Yes.
55.
55, 56, without memo policy.
Mhm.
Hardly go to the signature. Yes.
55, 56.
Signature of who? चलो withdraw करो ना. Memo is there ना. Yes.
58.
My lord, 55 appearance be noted, my lord. I am appearing 55 on behalf of railway, my lord.
55.
55 railway.
Okay.
My name is
They file a memo for withdrawing.
my lord.
Yes.
My name.
8.
Which matter? I cannot take it. So and so enters appearance for opposite party number 2. And seeks an agreement on the ground that the parties have settled their dispute. Release the matter after 2 weeks. Yes.
59.
Yes. 59.
And I told him, 500 rupees not paid. Or they received the extension of time. Extension of time, you would it's a possible and it would be the direction is that.
Extension of time for what?
Extension of time to surrender.
Why have you not surrendered?
Due to communication that I am not
Due for the reasons stated in the application, the application 2979. Stated in the application, the same is allowed. The petitioner is the time to surrender is extended up till 30th November. 30th November? 30th November. And rest of this order remains same. Yes.
61.
My lordship would turn to page 64 of the brief, my lord. 64 of the brief.
One minute, senior has served
IA yesterday
No, I would forego the IO.
and a reply.
I would forego the IO. What he has resorted, my lordship's order at page 64. My lordship just turns to page 64. This is my first. 64, my lordship category, paragraph 8. My lordship categorically stated, accordingly, the learned JMFC so-and-so is directed to conclude the trial, GR 101 of 2016, as expeditiously as possible, preferably within 6 months.
Yes.
He has come up against this order, hidden this order from the court, obtained a stay of proceeding without showing this to the court. My lordship sees the present order dated 9/10/2024. Interim order, IA. As an interim measure, it is directed that further proceedings of GR 101 of 2016 pending in the file of the learned JMFC shall remain stayed until further order.
Yes.
And he has filed,
I have
filed three 482 application, all dismissed. And all the three are before this honorable court. So the Supreme Court have given a judgment below of the Supreme Court, which categorically has imposed 50,000 fine on 3 grounds. One is direct, 3 grounds on which they have, one was by my Lord Justice Patnaik, R.K. Patnaik, who dismissed 482. Then he came up before my lordship. That was dismissed. Then he came up in revision under 389, it being an interlocutory order. That was a subclause 2. It was dismissed. Again, he has come up against this and obtained a stay. 10 witnesses have already been examined. My lordship sees. Therefore, in an identical matter, Supreme Court has imposed costs of 50,000, and I think my lordship is bound by that judgment, which I have given me before my lordship, verbatim, that is by Trivedi, on judgment dated, my lords, I'll only place 1 minute. The judgment dated 29th August 24. This is what it states, paragraph 13. In that view of the matter, the impugned order is set aside. The order passed by the session judge, respondent so-and-so has sufficiently delayed the proceeding for filing frivolous and untenable applications, one after the other, misusing the process of law. The present appeal is allowed with cost of 50,000 to be paid to the respondent. Within 2 weeks, the respondent shall deposit the cost in the office of the court, which shall be permitted to be withdrawn by the applicant. The session court is directed to proceed with the trial relating to the accused person as expeditiously as possible, and non-cooperation will entail in cancellation of the bail.
Yes. What do you say?
My submission is this, madam. First of all, my learned colleague says, learned senior says, that I have suppressed. Now he's referring to my petition itself. So it's not that I've suppressed. That's number one. I just want to put the record straight. That's not an allegation which is founded. It's unfounded, number one. And when it's a fact, my learned senior is correct, and I don't want to join issues on that. There has been 2 orders, both by this honorable court, and still then you come before your lordships. I'm not running away from that. But today, my lord, what I'm saying is, they have filed an objection on an IA. They have served me yesterday. My lord, kindly say what he says is, on the face of the earlier order, my lord, targeting the trial to be concluded within 6 months. The interim order which has been passed today, that needs to be very. My humble submission is this. Now, my kindly see the last order. I was led by senior advocate. He is not available today, but I'm not saying that. My only point is, my lord, if they are wanting a argument or final argument or I have a vacation of stay, my lord may allow me to file a reply. I'll file a reply. And by the way, my lord, we are not running away from the trial. As my learned senior said, this petition. File difficulty. Now,
my God.
1 minute. Madam, in this petition, we have come up before your lordships to say that we had filed 369 on a particular case at that point of time, before your lordships and before Justice Patnaik, the particular case record was not given. The fact was, when the court had given a report, asked the report for the collector to say, please tell us what has happened. Now, there is a collector report which had come in reply to Honorable Chief Justice Ken to the registrar. That is what it is. I'm not saying that whether it should be this or that.
What is this Indian order then? 12-9?
So 12-9 when we filed that for the charges to be amended. When we filed that report of the collector and said, this is the report of the collector which has been given in reply to a query raised by Honorable High Court. That was not considering that the charges should be amended. That was dismissed.
What amendment you are saying?
The charges. Charges were framed, my lord. Charges were framed.
Charge, I think he is wrongly framed.
My lord, in the report of the charge sheet itself, what we said is that, listen, there was no...
The investigation was carried out. Thereafter, he has challenged the cognizance was taken. He has challenged that order. This court has not inclined to interfere with the cognizance order. Thereafter, liberty was granted. He can raise that bunch at the time of framing of charge. Then he has challenged that framing of charge. That was also turned. And this honorable court has directed, let the trial be concluded within a specific period. Thereafter, my lord, he has, while the trial is going on, he can take that plea of failure or he can adduce evidence by giving
defense evidence, whatever.
My lord, defense witness. Without doing so, he has filed a petition under section 216 for alteration of the charge. And the court has turned down on the ground that primacy case is there. And at this juncture, I can go through the materials available with the records. For that, he has turned down the prayer of the petition. He has preferred a revision. The Israel court has also done everything. And he has passed a very reasoned order. And he has not considered, and thereafter only he has stated that since there is a bar under section 397(2), so he has rejected the intellectual order. For that, I will not interfere with the impugned order. But he has interfered, my lord. If your lordship will go through the order, judgment, if your lordship permit me, I will also place here. Then, my lord, he has filed this petition. And in this petition, this honorable court has granted stay. And my learned senior is agreed by that order and he has filed it. But the fact remains, my lord, at this juncture, this petition is not maintained. My humble concern, this petition is not maintained. Because the trial is already started and trial is going on. No doubt at any point of time that can be.
Why don't you raise all these points?
Evidence bias.
64, I think, 464 CRPC and all. Error in the framing of charges and all. That will not vitiate everything. You raise all these points.
It is an enabling provision. Supreme Court has written, I will only read that provision, paragraph 11. It says.
But today, Mr. Rai, today, Mr. Mohanty is asking for accommodation in a personal reason. I'll put it on next week.
All that I'm saying.
Maybe on 22nd.
Let the interim order go. Let the interim order go. All that I'm saying.
22nd.
I have nothing. Once it falls out of my lordship's grace, I will not even utter a word. But what I am saying.
What Mr. Mohanty says that he will be happy to argue the matter in your presence.
That's
the reason he is asking for time.
It says from 216.
22nd, he has some personal difficulty. Personal difficulty, let it be.
So my lordship would fix a date.
But I can read the bottom. You don't have a case. I can.
Case I understand. 216.
You save your energy for I'm only saying, management can your lordship do this for me. Can your lordship fix it along with the CRLMC, wherein your lordship has you have this is an exhaustive petition you prepared. Why am I saying this? In the minute, call for the record of CRLMC along with it. In the minute where your lordship has given 6 months time, that has actually expired in the meantime. Well, there also a report has come from the judicial expert and you keep on moving. Not for that. No, we have filed an extension. We have also filed an IA to bring to your lordship notice what is how your lordship's order is being interpreted by the lower court, wherein we are from going from Qatar, we are not even given accommodation for a day. Not for a day, I'll tell you, that's the whole difficulty if you target. This is another day. Unnecessary. Wherein we have reached at 2:30. The court says witness, we cannot examine the witness. We have filed the recall petition and not been considered against him. So that I am that CIMC. Call for the CRMC. CRMC number 7 of 2024. Yes. Dispose of.
233 is very clear, man.
And yes, maybe 22nd. And it's made clear that no further adjournment shall be. On any ground. Well, yes.
Yes.
62.
Interim order to continue for the
Yes.
Please, Madam, in this case, I filed an application for modification of the order, madam.
Modification.
Madam, the case is arising out of Belgian matter, madam. Earlier, the case was raised on bail.
What modification you want?
Para 5, madam.
Para 5, yes.
Para 5 of the order, madam. Taking into consideration the order threats and submission.
What modification?
Surrender and release and bail.
No. Anyway, I will not. This is the standard order. I will not. You, nothing. Yes.
Captain Evans.
I'm not inclined to make for the reasons stated in the applications.
One thing I will do, kindly extend the date.
For the reasons stated in the application, a date of surrendering so is extended to November, 30th November. The rest of the order remain changed. Yes, sir.
And another is JNF, the case is pending before the JNF Daspalla.
ঠিক
64.
না সেটা আপনার লিখছেন না কোর্ট হয়ে
Yes, 64. 2014 না ये लिस्ट लगा दियो. Yes.
65.
My lord, on behalf of Mr. KK Mishra, kindly may taken up this matter to the next week.
Any interim order is there? On request again.
Oblique.
February. Which is
64.
66.
Huh?
67 around.
Then counsel for the state submits that the file for this case missing in his office, her office, seeks for accommodation. Release the matter after 2 weeks.
67.
Yes.
May I please?
Yes.
67
pass over.
Your other chapter over my love. Yes, pass over.
You want to 330 pass over? Yes.
Mediation report.
Mediation report has
Mediation failed. Mediation failed. Prior to advancing my submission, I may permitted
for whom? Opposite petition.
Here, my lord, the petitioner is the maternal uncle. The opposite party who has filed the criminal case against him is one of the nephew. One of the nephew. Out of 5, he is one of the nephew. But the mother of the opposite party had filed a suit disputing the parentage of the present petitioner. মানে ভଉଣୀ ଭାଇ against କହିଲା ଯେ ମାନେ ମୋ ଭାଇ ନୁହେଁ ସେ ଦାଦାଙ୍କ that suit was compromised.
In the compromise, both parties were agreed, there was a compromise and compromise decree was passed. Subsequently, she got the land recorded in her name and subsequently she has sold the land. After that, she filed a criminal miscase under section 44, mother, the mother of the opposite party, that who is the complainant in the learning court below. File a criminal complaint case. Thereafter, file another petition under section 151 CRPC saying that the compromise decree which was upheld by practicing fraud. That case was brought to this honorable court. It was stayed for some time. Thereafter, it was remanded to the learned trial court and now it is pending. At this stage, a proceeding under section 144 was filed seeking restraint order against me to make any construction. Well, that was also dismissed on the ground that since it is essentially it is a civil dispute, the criminal court will not interfere. Thereafter, when the mother failed in all the ways and only to proceeding on the 151 proceeding is pending, CMA number 53 of 2013 correct, is pending. Now, he has filed the criminal case making the same allegation that I am the son of another person. I have obtained the decree by committing fraud. All those things are making allegation. He has filed the criminal case. That proceeding is not to be. What do you say? I prefer civil proceedings are there. Cross cases. 144 proceeding is concluded. Yes, all documents I have given. That apartment I have also given. Annex 7 is not ready. Yes, sir. Madam, pursuant to the order of this court, the matter was referred to mediation, and the mediation, the High Court Mediation Center has placed on record a mediation report dated 17/2/2023. Inter stating that the mediation could not be successful. My lord, only successful. Matter is ripe for hearing. List it on such and such date. The interim order to continue. Yes.
68.
Yes. The interim order may continue. And interim order to continue. Yes. 68 and 69, the chief engineer and he has been granted interim protection. Last occasion, the Vigilance Council asked that he will apprise this court about the status, and he has some other information. Last occasion that was just today. Have you got it? The petitioner has filed number of cases. I will give the list. Let it be heard at a time. In this same petitioner, this petitioner. How many cases you filed? Here two cases. Here two cases, and other two cases are also there. And earlier he has the approaching same set of allegations in respect of other. I think how many cases you have filed? These are two GR cases and two prosecutorial applications filed, and other GR cases, one was in Barampur that is disposed of, and one Bhavanpatna that is disposed of. As far as these cases you have, now it is two. Four cases against you. Yes, there are four as far as my knowledge goes. And one revision is also pending last week, your lordship. That was arguing by this some other I don't know that. Ask how many cases are. I have these two cases disposed of. Please ask you. The cognizance order has been challenged. And let us not go into the merit of the case because you have taken time. In respect of co-accused, this one, that's what I wanted to know. Because these cases are arising out of an FIR of 2010. Interim order operate kortile to charge frame din nathiru. That's what that you wanted to know. That's what Lassi wanted to know. And Mr. S.K. Das told he is asset on this court. And see, 2010 case. Yes. And Kami has taken 2015. It is lingering at their behest.
No. I will not name the charge. I will not name the affair. In the charging by taking resort to open court, they have charged me. I was not naming the affair. You have to get the instruction, proper instruction. Get the instruction. 68, 69, na? 68 and 69. 68, 69. The Vigilance Council has to seek instruction regarding the status of the present case and ascertain the attributability factor for delay in the trial, delay in trial, and submit the same. If it is attributable to you, then it will call for that will be better also. You try it, doesn't happen, then I'll take, yes. Entry mode to continue, yes. Till accept extent date, I will give it. 4 minutes, yes.
70. 6.
70. I've got the typed copy of that initial statement you also wanted. It's like and to avoid pending, this complaint has been lodged. The lordship wanted to see the initial statement because only one paragraph, the entire JPM for OP2. OP2, one judiciary diary was appearing, my lord. Last 2 days he has not appeared. Yes, Mr. Jina. There is a complaint case, my lord. He has nothing to do.
And since the party has appeared,
Yes.
and he is not taking steps, my lord, your losses can issue press notice of.
2016, the and no allegation. There is no allegation against me. These two petitioners. There is absolutely no allegation. You will also see the complaint, the initial statement, last paragraph. The only allegation against one Sanjeev Shaw. Mr. Dalai appeared, no? Appeared in 2023. Thereafter, 3 days he has not appeared, my lord. 2 days. Yes. This is the third. I'll issue court notice to Mr. Dalai. Issue court notice to Mr. Dalai. Non-appears for opposite party number 2 is non-appears for opposite party number 2 since last 2 occasions. The present case is pending since 2016. Interim order dated 27/10/2016 is operating since then. Issue notice to the council for opposite party number 2, Mr. Dalai. Release the matter and say interim order continue. Yes. 71, Mr. Mahanti is on the legs, my lord. I have requested me to take a time for this sort of some other date next week. So next week, Mr. Mahanti. Next week. Yeah, interim order was there. Let interim order continue. Yes. 72.
State was to come ready in the matter the other day, giving the reference.
You received it? Yes, just see, Mr. Jana. Yes.
Of order of the arrest to be refused in this case, surrendered in the court of and after completion of sufficient evidence on the school statement.
321 petition ଦେଲୁ ଯୋଉଟା allow ହେଲା ସେମାନେ allow ହେଲା state ର
NSS 6 ଦେଖନ୍ତୁ
321 petition was challenged by lots was challenged by me in this court in a CRL and that was set aside.
That could not have been.
You mean it could not have been.
You were supposed to take some instruction. See, these are the matters pending from years, you know. State has never taken any step.
A second.
I instructed the registry to list all the matter where the change operating. You people are keeping quiet. And when the matters are listed, you don't get instruction, what it do then?
Complement the fair question.
Why I am submitting that, Mr. Panda, that could not be correct. WPCRA,
They are not ready at all. Petitioner, the state council is not ready in the present matter.
One CC case.
Huh?
One CC case, man.
It is one CC case.
My lord, an application for quashing the order of cognizance related in one CC case number. So there is a private party matter.
No, see, you have also investigated that you file form.
Case 26 দেখুন আগে case 26
an application
সেটা দেখিয়ে মারবো বলি case 26 দেখুন order impugned is at page 28.
Yes,
this order is 12/12/2015 sir, page 28.
Where is the cognizance? From bar करता नहीं?
Page 28 नहीं
नहीं नोर अपने की prayer.
page 28. Yes.
Page 28 नहीं page 28.
Release the matter for final disposal on after 2 weeks. Is an interim order to continue. Get ready, Mr. Jana. Get ready.
Interim order.
These are interim order to continue. These are the matters pending since 2017-16.
Prayer is to put cognizance.
What do you
not the prayer? The order which my lord senior is referring.
No, you prepare it and come. Yes.
I get a part. My lord, I have 65. I don't 60. I'm sorry. It is my lord.
I don't know. 55 might have been over.
65. 65.
For
confirmation of delay. In fact, there is an idea.
I have already passed. Let me.
My lord, madam is in that case. You also will check.
Huh?
Madam is in that case.
Yes, record. I will accommodate this week only. I am very clear. Yes. Scan copy of LCR code.
My lord is referring to WPCRL that was filed in 2013. This order is of 2015, which I am questioning here. How could it, how will the chair on the basis of the protection which I filed?
I understand it. I've gone to let it come. We'll see.
LCR has to decide. No, LCR yet has to.
Yes.
Lordship. In this application, Lordship, I have sought for quashing.
Are you reading this? Yes.
See the instruction, the instruction that instruction is not submitted. As to whether the inspector of commercial tax was authorized by the commissioner to detain the vehicles.
Yes.
That authorization is to submit.
Have you seen it?
That
Got the instruction.
instruction is
You have seen on 29/2/2015.
I have obtained the instruction on that was
Instruction dated?
instruction dated 13/3/2024.
Okay.
That notification, a copy will be given to me so that I will
Sorry, my lord, with all respect. At this stage, we cannot supply any copy to him because he has to obtain the 207. He has to appear and
207. There is no such record in the prosecution case. The question is a notification of the convenience has been challenged. The case is that, let me paste the facts. The case is that a case under section 13(1)(b) and section 120(d) of the Penal Code has been instituted against me.
Yes.
I was working as the inspector of commercial tax, and for a short period, I was posted in Jharsuguda goods shed of the railway.
So many charge sheet if case is made out, then you have to face it cognizance is taken. So many charge sheet.
Yes, Lordship. Let me prove the facts and Lordship will understand it.
Let us see the charge sheet in the
Charge sheet আমি দিয়েছি Lordship ওটা
Where is that?
It's no,
Page 37.
the facts of the case is that
Instruction by the
Mr. Let's what it, I will read it.
Yes.
May I read it, let's see.
Hard copy होगा दिल्ली का
Another copy may I supply?
if you have any copy
Yes, it will be.
yes
So,
मत दियो तो उधर से पढ़ियो
charge sheet Xerox copy होगा, charge sheet copy. Brief facts of the case is that Mr.
this is charge sheet
Charge sheet, allegation in the charge sheet. Brief facts of the case is that Mr. Sibo Sankar Trading Company, Kanpur, UP had sent 555 quintals of wheat of self at Jharsuguda by the RR number 604197 dated 25/9/2000 of Kanpur Central Goods Shed, which was received by Sri Gulab Chand Agrawal, proprietor of the farm, without paying initial sell tax at Jharsuguda. Messrs. Modi Oil Mill Sagar had sent 555 quintals of wheat of self at Jharsuguda by the RR number 515698 dated 29/9/2000 of Sagar Railway Goods Shed, which was received at Jharsuguda Goods Shed by me, Kapil Kumar, without paying initial sell tax. Messrs. Ramchandra Traders Sagar had sent 555 quintals of wheat.
you are the commercial tax officer
I am the inspector of commercial tax.
yes
They say the basic allegation is that they say that in the FIR it is stated that three farms, one is Modi Oil Mill Sagar, second one is Sibo Trading Company Kanpur, and the third one is Messrs. Ramachandra Traders of Sagar. All of these farms had sent 555 quintals each of wheat to Jharsuguda to various persons.
yes
And it is alleged in the FIR that without realizing the sell tax leviable on the goods, the petitioner permitted the goods to be lifted from the railway side.
yes
And out of these three farms, the charge sheet, when the charge sheet was submitted, the farm Messrs. Sibo Trading Company was deleted as because it is stated that the said farm had paid sales tax. And only against two farms, that is Modi Oil Mills and Messrs. Ramachandra Traders, it is stated that an amount of rupees 50,616 was due for remunerational sell tax, which the petitioner did not collect.
Yes.
And in this regard, similar case was adjudicated upon by this honorable court, reported in 2013 second ILR Kotak 6862, the case of Kamal Prasad Bondia versus State of Orissa, the copy of which is there on the record.
yes
Let's see what the decision. Kamal, Lordship, may I come to para 2, Lordship? Compendium of relevant facts for disposal of the criminal miscase is as follows. On 2/8/2000 and 3/8/2000, this petitioner, being the agent of Messrs. Bondia Flour and Oil Mills Jharsuguda, had received 21 wagons of wheat weighing about 12,204 quintals of railway goods at Jharsuguda. The wheat in question was purchased and transported from Messrs. Ma Durga Edible Products Private Limited, Chiranjeev Lal Satyanarayan and Kedarnath Hariram, all of Uttar Pradesh. Messrs. Bondia Flour and Oil Mills Private Limited had paid a sum of rupees 85.
what is the ratio
Ratio is that this honorable court held that sell tax will be realizable only when it is sold. So, as the goods said, when the goods are lifted, sell tax are not leviable. Sell tax can only be due when the goods is sold.
Sale is
That means when sale is made.
effective yes.
And accordingly, this honorable court quashed the order of provisions against that person.
yes
And the case is similar. And I am the inspector.
What Mohanlal says?
Lordship,
Mohanlal Supreme Court.
Mohanlal. This is another point, Lordship, where the informant becomes the investigating officer. These are not pressing at this stage.
Yes.
Now, Lordship,
Let him come. Sale is not effective. That's what he says. Yes.
then, Lordship, the second thing that is relevant for this purpose is that the petitioner was in temporary charge from 311 to 1511, and the goods in respect of maybe and means was lifted on 311. The timing is not there. The petitioner entered into discharge in the afternoon. And so if it is in the forenoon, these are facts. No, these are facts. These are facts, but on the point of law also, it is point of law you have it. Yes, not told. Yes, sir.
Only lifted from the.
Yes, Lordship.
At the gate of.
And I am covered by the decision.
Yes.
My learned friend disputed the decision on the ground that in that case he was the agent of the person concerned. That is one of the facts. But the fact remains that the has also held that tax is not leviable. And again, section 18 of the Act says that my learned friends has in his written argument submitted that it was his duty to detain the vehicle. So far as detaining the vehicle is concerned, section 18 of the Celtics Act says that any officer below the assistant commercial tax officer has no authority to detain any vehicle. And that is why this Honorable Court directed him to produce the notification whereby special authority is given to an inspector to detain the vehicle.
Yes. So where a judgment is concerned, that is in respect to another case, and he was the agent. And my lord was held that so far as he was the agent, it is not his duty to see verify the receipt or whether it is genuine or not. He has acted on behalf of the proprietor. That's why he has only received the goods from the railway point. And so far as role of the petition is concerned, law point is concerned. Page 2. My notes.
The notes.
Page 2.
Your notes is not there.
Then I am giving another.
Yes, notes is there.
Page 2.
Okay.
Here the consignor sent the goods through railway organ to the Jharsuguda point. So when it is the consignor, when the consignor sent the goods, there will be triplicate receipt. So one will be written at the point of the consignor, one will come with the goods, and it will be produced by the tax officer. It will be verified by the tax officer. Then the goods will be released. Here, what has happened in section 16B. I have given noted, no persons are transported from any railway station, steam station, airport, post office, or from any other place whatsoever notified in this gap by the state government any consignment of such goods exceeding the such quantity as may be specified in the notification, except in accordance with the condition as may be prescribed, and such conditions shall be made with a view to ensuring that there is no evasion of tax payable under this act. Any prescribed authority or officer who may be authorized by the commissioner in this gap for the purpose of verifying whether any goods are being transported in contravention of the provision of subsection 1 and subject to such restriction as may prescribe the intercept, detain, and such any road vehicles are reworked so and so. And 94B, here the duty impose restriction on movement of goods from railway station by any person. The sale tax officer having jurisdiction is required to verify the railway receipt and proof for payment of sale tax on the consigned goods, and prove his counter signature with seal on the same, so as to ensure the payment of Orissa sale tax on the said consigned goods and detailed consignor and consignee. That has not been complied. No, that has not been complied. By that process, he facilitated to lift the goods That is the role, and he was the public servant, he abused his official position and facilitated to commit the offence. So that judgment will not be applicable.
Lordship, para 12, Lordship may kindly see of the judgment. Para 12, one minute. Let me place para 12.
Yes.
It is not in dispute that cell tax authority is entitled to impose cell tax in accordance with the relevant act and rules upon a person who carries on the business of selling goods and who has in the customary course of business authority to sell goods belonging to the principal. A clearing or forwarding agent like the petitioner or a person transporting goods on behalf of the dealer does not carry on the business of selling goods and does not have in the customary course of the business authority to sell goods belonging to the dealer whose goods he books or receives. There has to be a reasonable and proximate connection between the transaction of sale and the clearing or forwarding agent or person transporting the goods before the cell tax authority can, in exercise of the power, levy cell tax. From the materials on record, there is nothing to show that in the present case there was such close and direct connection between the transaction of sale of goods by the seller and the dealing and the clearing or forwarding agent or the agent who or received such goods.
What do you want to say?
That's it.
What do you want to say?
I want to say that this honorable court has made it clear that the question of levying the cell tax arises only when there is a sale. By receiving it does not, there is no cell tax leviable. And secondly, my learned friend pointed out to the provisions, and that provisions which he read contains the word cell tax officer. I am not the cell tax officer. Below the cell tax officer, there is an assistant cell tax officer. And below the assistant cell tax officer, there is the inspector of commercial tax. And my position, the section 18 of the Act, which I have ever in para, which I have ever para 17 of the Act, which I have ever in para 9 of my petition. Let's kindly see para 9 of my petition.
Yes.
That as per the provisions of section 17 of the Orissa Cell Tax Act 1947, subject to such conditions and restrictions as the state government may by general and special order impose, the commissioner may by order in writing delegate any of his powers and duties under the act or rules made thereunder to any person appointed under section 3 to assist him as per Rule 94A of Orissa Cell Tax Rules 1947, an officer of the Commercial Tax Department not below the rank of an assistant cell tax officer can intercept a goods vehicle at any place other than a checkpost or a barrier building. Evidently, RR unit comes under this category and is neither a checkpost nor barrier. As per the provisions of Rule 94B of the aforesaid rules, any person transporting goods from the railway goods shed has to produce the railway receipt for counter signature before the cell tax authority, not below the rank of assistant cell tax officer, having jurisdiction for the purpose of obtaining delivery of such consignment from the public carrier. The person is required to make a written declaration in form XXXII in duplicate duly signed by such cell tax authority as per section 16B2 of the aforesaid act. Any prescribed authority or officer who may be authorized by the
Yes.
Lordship. So I have pointed out in detail, and that is why this honorable court directed him to produce the authorization.
We'll continue part it next week. And let him produce the authorization. I'll give a copy of that to me. If you have anything, you get. That authorization is not a part of the police. Doesn't give, then it's all right. Next, parted, keep it. Parted. Lordship have interim order. Interim order, yes.
74. Where's the universe?
On dealing matters? Hmm? Any fresh matter? Yes. Yes.
May I please your lordship? Lordship, may kindly turn to pages 7 and 8.
7 and 8.
My lord. 8 is material. Evidence has been taken in a 1cc case by the SDGM Atward.
Yes.
Your lordship may then kindly turn to page the complaint case itself. Page 10.
Yes.
Nagdamara Vivarani. ଏହାର ସୁଯୋଗ ନେଇ ଆମର ସ୍ୱାମୀ ଆମକୁ ଫୋନ କରି ସବୁ କଥା ସମାଧାନ କରିବା ପାଇଁ ବ୍ରହ୍ମପୁରକୁ ଡକାଇଲେ, ଯାହା ଫଳରେ ଆମେ ସରଳ ବିଶ୍ୱାସ କରି ଆମ ସାଥିରେ ଉପରବର୍ଣ୍ଣିତ 2 ଜଣ ସାକ୍ଷୀଙ୍କୁ ଧରି 18/2/18 ତାରିଖ ଦିନ ବ୍ରହ୍ମପୁର ଠାରେ ପହଞ୍ଚିଲୁ। ସେଠାରେ ପହଞ୍ଚିବା ପରେ ମୋ ସ୍ୱାମୀ ଆମ୍ଭମାନଙ୍କୁ ନେଇ ଏକ ଅଜଣା ଜାଗାକୁ ଗଲେ ଏବଂ ଉପରୋକ୍ତ ସାକ୍ଷୀମାନଙ୍କୁ ବାହାରେ ରଖି ଆମକୁ ଘର ଭିତରକୁ ନେଲେ। ସେଠାରେ ଆଗରୁ ପ୍ରସ୍ତୁତ ଥିବା 2 ନମ୍ବର ଏବଂ ଆମ ସ୍ୱାମୀ ଗ୍ରୁପର 2 ନମ୍ବର ଏବଂ ଆମ ସ୍ୱାମୀ ଆମକୁ ଯୋଗଦେଇଛି ଲଗ୍ନ କରି ଶୋଇଛୁ। ବ୍ରହ୍ମପୁର convention being taken by the SDGM Atward.
Regarding of the private complaint, lordship.
Yes.
This introduced to it too.
Notice has been-
Yes.
There is a dispute between the husband and wife. The wife has called for a conciliation at Barampur, where the husband resides. She came from Athavada to Barampur. There she has been assaulted. And due to some of the difficulties, she couldn't report at Barampur. It is mentioned.
Where the offense has taken place?
Offense has been committed at Barampur. In the 1cc case manner. Thereafter she came to Athavada at her parental house. There she has instituted this case. And upon inquiry, the court has taken cognizance, rightly, my lord. Thereafter, they have filed this challenging the order of cognizance. Your lordship may kindly have a glance at that the years of occurrence. Thereafter, they have filed this case. They didn't pursue. They have filed another case for transfer of those cases. But those cases were disposed of and dismissed. Thereafter, they came up to this honorable court for transfer of the same proceeding matter, which was also dismissed in 2023. Now this case has been pursued.
Where are those orders?
My lord, I'm supplying my lord.
No, not supplying. Have you filed?
No, my lord.
The students who entered appearance for opposite party number 2 and 6 1 week time to file the response to the petition. Let him do so within a week and lease the matter response. Entry mode to continue. Yes. File all the orders on top.
Yes. Yes.
Yeah. What is there any chance of settlement? No.
No, my lord. He is avoiding to pay the maintenance, my lord. Maintenance has already been awarded. He is avoiding to pay. And
Therefore, you file 354 against your husband.
Another accused person is another accused.
I'm teaching. To get maintenance, you have employed this method. No, something, put that a story, Barampur, something happened in the. Whatever. This is the better that you settle.
But in some cases, they are well.
Better would be to settle.
Husband is not settling how to write.
Let us, yes. Continue. When I hear Mr. Mahapadra 3 o'clock some matter I teach, I want you have to take a see time, fixing time is very difficult. 100 matters I am not able to. That's the.
May I please lordship at this hour I will not, I will never.
What is the urgency?
Urgency, my lord, because of the pendency of the present case, the petitioner who is due to retire in next month
See, her retirement benefits or other things are likely to be affected.
Before committing a crime, he should have thought of,
No, she had not committed any crime.
but he is convicted.
No, not conviction is not there.
Then
We are challenging the summoning order without cognizance. That matter 130 to matter will also hard this matter.
Then it will not affect your service.
But you won't see they have any criminal case. Since this is criminal in nature, so any day, may lawsuit, any day, subject to lawsuit, so can it be press admission?
Is the same issue where your son has taken money for medical?
Yes. That is the matter. And on this point, since there we don't have any decision on this point, yes, your lordship. I am very much complainant.
Why don't you pay something and finish it up? Why? No, fact of the matter is your son has taken
Son is they are paid to my son, whatever they have done, that will be done. That can be done.
Fact remains, your son has taken money from them for arranging a seat in the medical college.
Yes, your lord.
Okay?
Yes.
When these people started asking and creating problem in your house, you issue a check.
Yes.
That is dishonor. Today on technicality you say no, it's not legally recoverable. You saved your son by giving a check and got it dishonor.
I think Chandra said
losing a job,
Yes.
then it's good. That your son has done all these things, you have protected your son.
That the public policy, may I say one thing?
Technically you may be correct, but fact remains your son has taken money. Why will you go and check that?
Because of this untold situation happened. I'm not disputing. I'm still saying that
You pay some money.
my son will pay because he has taken, he's inside custody. She had managed.
How many people? How many students?
There are, at my information is concerned, four cases. Four cases. When I am 35, I'm to decide the legal issue here.
Legally problem is the amount, the check which she has given is not legally recoverable. Therefore I say that you get some judgment.
I have given some judgment, hand out some judgment Supreme Court, my lord. The check has been issued. He has not disputed in the complaint case, my lord, nor disputed the check. So legally liability is a form, my lord.
I told you, I framed the question. I am trying to search for research for you. I said that 139 presumption, if legally not recoverable or legally recoverable, that is a presumption operates against him. It is a rebuttable presumption. He has to face the trial and establish that.
Yes,
on that, you get some judgment.
my lord.
Because he is challenging today cognizance order.
No, that is not convenience.
But in the initial stage, you have to face the trial and prove that.
No.
If it presumption operates against you. You are admitting that you have given the check.
Yes.
Admitting it.
Yes.
Then the moment you admit it, that you have given the check,
I am also supported by numbers of judgments where on the direct issue, this transaction was for the purpose of getting a seat in the government medical college. The amount was paid and the accused admitted the signature, admitted the issuance. Still then court held that the court will not be party to recovery of any amount which has been in constitution of illegal. No. Cognizance. Karnataka High Court and Madras High Court. Madras High Court, there is, I had a last what to do. Last giving him. I have judgment. And I think I have also come with the compilation for your lordship's reference. Everything I have prepared. So, may I request your lordship?
roll over to next year and next week.
Yes, admission.
Roll over next week.
Yes, admission.
Yes. Continue it. Let it continue. Directly cover what to do. Because in any case, his son is already there in jail. You can convict him whatever you do.
No. Question of trial.
My lord, sir.
My lords, item 133, my lords, in weekly list. Your lordship has said that the matter will be heard at 3:30 today. So this is regarding
Forced to appear before the company in a criminal case. Covered by judgment of this court and also
Which item you are talking about?
78. The only problem it may not reach today, Malad, you also may keep it to 22nd. Interim order has expired in the meantime. Lordship last order was
Where was the interim order, Swami?
interim order was passed on 15/7/2023. It was till 28/7/23, but thereafter the matter was not listed on that.
Oh, date is given till 28/7/2020.
That is the problem.
Right, an interim order pass on. Initial interim order was.
First order was passed on 22/9/22.
22/9/2022. Mr. Paul, who is seeking adjournment?
CGC has to file the counter. They have taken time. You also may see the last order.
Counter has not yet been filed by the opposite party. Hence, the matter is adjourned to such and such date. The interim order pass on 22/9/2022 shall continue. Till further order. Yes.
75 also, 75 is further.
She'll give further orders. Yes.
75 also interim order will continue till the next date. 75.
I'm not taking up why it's not expiring. In case it expired, already expired. I'm not. Yes, sir. Any
76, my lord, I'll assist your lordships by making a detailed chart, my lords.
Let it be there and the board will adjust and give it.
But
yes, fine. Any
my lords, there is one mentioning, my lords, item number 133 in the weekly list. My lords.
Or will adjust and give.
Last week. My lords, item 133 in the weekly list. The lordship said we will take it 3:30 today. Now, this is the matter in Baganagar railway accident case. My lords, my lords, only one submission, my lord, the trial has been going on there. In fact, my lord, this is revision whereby I have been charged under 304 part 2. My lord, the basic ingredient of 302, 99, 300 is not applied in my case. In fact, my lord, this is exactly similar to Keshav Mahindra case in this Bhopal tragedy matter. So, my lords, the trial is going on, my lord, is posted on 18th and 19th. So, your lordship can kindly hear us on main issue. My lords?
You are against which order?
Against an order of revision, my lords, discharge order, whereby I have been charged under 304 part 2. My specific contention that the ingredients of 219 and 300 IPC is not applied has not even been considered by the Learned Session Special Judge. So therefore, my lords, I am before your lordships. This honorable court by 30th August, your lordship has admitted the matter and has posted for final arguments on 4th of October. My lords, the matter has not come. The only problem is, my lord, the trial is going on, my lords. If the trial is going on, then the entire revision will be infructuous. So your lordship can call for the records from the trial court at least, my lord, so that I can demonstrate that even the fulcrum of the case is completely without any effect, because the Chief Commissioner of Railway Safety has given a permission to us to change the ELB, the electronic lifting board in the station.
When was your application dismissed by the trial court?
Application was dismissed on, my lords, in this was dismissed on, my lords, on it's in fact, my lord, in page number 193, it is on 5th April, my lord, 24. My lord, then I have applied for a bail. My bail was reserved on 21st of April. My lord, then I thought that after the bail is ended, I will file a revision petition. And
so what best I can do is from weekly list I can bring it to the supplementary list. That's all.
Lords, can it be heard tomorrow, my lord, so that the trial is on 18th and 19th?
I will include it tomorrow. Just see, include it tomorrow if I can get time, and definitely do it. That much I can do that from the weekly list and put it in the supplementary list. Okay.
Well, I want to continue the weekly list.
Even the supplementary list could not be adjusted.
So tomorrow, talk in at least higher up in the supplementary list, my lord, so that we can.
I put it in the supplementary list. Let us see. Tomorrow, not tomorrow may not be possible, but put it on 19th. Put it on 19th.
19th, the trial is going on, my lord. 18th and 19th, both the dates, cross-examinations are there.
All right, nothing will happen. On the same day, you will not be committed. Don't worry.
91, 122 in that 11th November list, Hon'Ble.
Please don't tell anything. Let it be.
Supplementary is my item 88, my lord. Can it be taken up tomorrow? Because my lord, in that case, my lord, for accused statement, the matter has been kept, trial court has kept the matter yesterday, my lord. I have given a time petition and it has adjourned to 18th, my lord.
What are you challenging?
My lord, 311 petition that the for recalling of 38 petition, 311 petition, my lord. It was 311 petition which was rejected, my lord. Item 88, my lord. So
88.
yes, not the those the appearance, the
1 minute.
yes, my lord.
88. Where is so many? 88. Mr. Jana, who is getting 80? Just if one opportunity could be given, I'll finish it up right now.
Yes.
1 minute. 88. Let us see. Where is 311 application?
Yes, my lord. 311 petition was rejected.
Where is that application?
Application, my lord. That is at annexure 2, my lord. At the order.
Application I'm asking you about. You don't file application, you don't file proposed question, you don't file the evidence of the witnesses to whom you want to recall. Nothing.
No, I filed that copy of the deposition I filed, my lord.
Where is that?
That is a letter I have filed, but
it's not there. It's not.
I've given as a
It's
memo.
not there, Basi. Not there.
As memo I filed, I've given the copy to the state council.
Except the application under 311 which is rejected, you are not placed on recording. Petitioner is allowed to.
Kindly.
What can I do? You file an incomplete application. You are shouted at the top of your voice. I wanted to dispose it up right now. Nothing is there. So casually petitions are being filed and shouting at the top of voice.
Filed, but
is it expected that you file an application for recalling without the application, without the statement, without anything? Only MP order and pass the order.
No,
That is it. After 2 weeks. After 2 weeks. That is it.
my lord, on next week on
No, nothing. Nothing. So casually petitions are being filed without any particular, without any document. Yes.
your lordship has told me on last occasion to file affidavit from the informer.
Where is that? I don't know. Where is that?
I filed, I have the receipt
Receipt it in your pocket.
I have receipt, my lord. I have the receipt.
I have received from my record. What can I do? You have to make it sure. Why have you, at the first instance, why you, along with the petition, you have not filed? You wasted that day 1 year.
Yes, my lord. My mistake.
Then? 3 years you have wasted for this.
I have
Where
given,
you have not filed that.
I have given copy to the state council.
This is very casual approach. I should not entertain it all. It's, you know the pressure of the court and you don't understand.
Next week on any day.
No question. If you speak single word, I'll put it in February. Because it is for your mistake, let the your client suffer. Yes.
Item number 94.
90?
94. I on my the trial court, your lordship granted an interim order. Your lordship may kindly see that order. Your lordship may kindly.
What do you want now?
But here, the trial court, in spite of your lordship's order that I will file an application for adjournment and in the adjournment sent, he has proceeded in the matter.
Where is that order?
Yes, I have given along with my memo of,
Yes.
along with my memo, I have given and supplying a copy. Your lordship is memo which I filed for mentioning, I have given that copy.
Yes.
And I have seen that your lordship passed this order. It's a copy of.
20 order.
Yes.
It will pass this order.
Yes.
What is the
Application for adjournment, it will be adjourned for 6 weeks. Thereafter, it was not listed. The learned trial court said that because it has not been extended for 6 weeks.
how can you find the fault with the fault with
I have filed an application for adjournment after 6 weeks saying that it has not been listed, we have mentioned. He should have at least laid down the hands.
Don't complain against the magistrate. Magistrate is correct. If the interim order is passed saying that for 6 weeks you can get an agreement, after 6 weeks that
If it is not listed, it is not our fault.
that is not the fault of the magistrate also.
But somehow this is the order.
Then why are you complaining against the magistrate? You simply say that you extend the interim order. That's all.
No, I tried that showing the list that I tried.
Don't make allegation against,
Application, madam.
you said despite the order is proceeding.
Yes.
There is no order.
No, order is that 6 weeks adjournment.
6 weeks over. Thereafter you can proceed.
But as per the view of the apex court, madam.
I would have extended it because of your wrong statement. I am not doing it. List it after next week.
But your lordship.
No. You have made a wrong statement.
It is not a wrong statement. I told that.
You have given impression as if the vice state is wrong.
I don't
Please respect some the court proceedings.
question for adjournment. He rejects that saying because it has not been.
Obviously, what can he do?
So I mentioned before that.
If he would have proceeded and not proceeded, somebody might have complained, saying that despite there is no order, he is not proceeding.
Once that is sub judice in a higher court, he should act.
That is a different choice. There is no stay as of today.
Lordship may post it any other day and file an application for adjournment, he will adjourn it. I am
Mr. Bose, learned counsel for the petitioner submits that on 28/8/2024, the coordinated bench of this court had passed an interim order directing him to move application before the trial court seeking adjournment for 6 weeks.
Yes.
However, the 6 weeks has already been expired, and the present criminal MC could not be listed within that 6 weeks. Therefore, the trial court has started proceeding with the matter, and he seeks extension of the interim order passed on 28/8/2024. Regarding it to the statement made at the bar, the interim order passed on 28/8/2024 is extended till further orders. Yes, is the matter forward. Don't make that allegation. It is not expected from you.
It's an allegation. I think I could not communicate it properly.
Yes.
Item number 91.
Item 79.
Yes, that too seems. Any
My lord, item number 91.
91. Okay.
My lord, item number 91. My lord, I have filed 167 against this LMC. Against 167. But already everything has been done.
Who is appearing for? Yes.
Mr. Vasudev Pujari was there. My lord, everything is concluded, but judgment also I have supplied. Then your lordship will
Let it come
tomorrow, my lord.
next week. Any very urgent matter? Otherwise, all the matters will be adjusted next week. Next week.
Pardon, your lordship, item 55, 56, your lordship, I am seeking permission to withdraw, your lordship.
55, 56. Signature below the problem.
Fresh,
But I've done it, but good that you have done it. Yes.
fresh memo.
Yes.
Obliged.